All right. We're on the record in cause number DF 2314956. Councils, will you please announce for the record?
Caitlin Caskey for petitioner.
Michael Granata for respondent.
All right. And those who intend to testify, please stand and raise your right hand. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth? Thank you. You all may be seated. We are here today on a reset for a motion for enforcement for alleged violations of the possession and access schedule in the underlying order. Prior to going on the record, the party stipulated to some exhibits, and those exhibits are petitioners exhibits 1 through 4, respondents exhibits 1 through 20, and they are all admitted. Are there any preliminary matters that the court needs to take up first?
I would just ask them to take judicial notice of the prior order.
The court takes judicial notice of the prior order as well as all contents of the court's file.
Judge, do you prefer a brief opening statement?
The opening is 100% up to the attorneys. If you're asking, do I necessarily need it? No.
Okay. Okay.
But if you all wanted to go right ahead, you have 15 minutes aside that will include any opening and closing, should you choose to make one. And it would also include the examination of your witnesses.
Okay.
All right. Counsel, at this time, would you like to make an opening statement?
No, Your
Honor. Okay. Okay. So, Attorney Caskey, you may call your first witness.
I call Mr. Slater.
All right. Mr. Slater, if you have a seat right here, and make sure you pull the microphone close to your mouth, okay? And we are streaming on the court's YouTube channel in compliance with the Texas Open Courts Act. The courtroom doors are also open as well.
Right.
Whenever you're ready, counsel, you may proceed.
Good morning, Mr. Slater.
Good morning.
How are you?
I'm good.
Okay, we're going to start with just some background questions. Who is subject to the suit? How are you related to them?
She's my daughter's mother.
Okay, and who's your daughter?
Aura.
And how old is she?
She's 4.
And were you ever married to Miss Brooks?
No, ma'am.
Okay, and so you were never married. Were you in a relationship?
Yes.
Okay, and when did that relationship end?
Probably before, a little bit before Aura was born.
Okay, and how was your visitation like before that?
It was okay.
Okay, and then at some point you decided you needed to get an order in place, correct?
Yes, ma'am.
Or you guys decided, and so that's the order that's currently in place.
Yes, ma'am.
Okay, and how has visitations been going since that order's been in place?
It's been okay, but not through the whole order.
Okay, so let's talk about you alleged 13 different violations. Is that correct?
Yes, ma'am.
Okay, so let's talk about the first one. The first violation you stated occurred on Saturday, November 16th. Is that correct?
Yes, ma'am.
Okay. Can you look at what's been previously marked Exhibit 1?
Mm-hmm.
And at that time, it's a Saturday. Why is it a Saturday that you're picking her up?
Because the judge that initial gave us the black and white, the court order, she gave us a 90-day, first 90 days at 10 to 11 or 12, and then the next 90 days from 11 to 12. So
you had like a step-up schedule?
Yes, ma'am.
Okay, and now where are you at in that step-up schedule?
We're on the regular court order.
I'm going to object as relevance because.
Okay, that's fine. I can get to the point. I was just trying to get.
Sustain.
Well, we're on the second amended motion, and that's not a date that's listed.
Sustain.
Oh, okay, all right, sorry. Okay.
Go ahead.
Okay. So this has been previously marked as Respondent's Exhibit 1.
Yes, ma'am.
And what's going on in that text message?
I'm letting her know that I'm here and that I'm picking up Aura, and then that there's traffic on the highway, and I'll be a little late.
And what time did you get there?
I got there at 10:11.
And was she there?
No, ma'am.
Were you able to see your daughter that day?
No, ma'am.
Okay. Let's move on to Exhibit 2, previously marked Respondent's Exhibit 2. What's going on that text message?
I was asking for order to be dropped off. I was seeing where it was.
Were you supposed to get her that day?
Yes, ma'am.
Did you?
No, ma'am.
Let's turn to Exhibit 4. That's a Thursday, correct?
Yes, ma'am.
Tell me about what's happening in that.
I was letting her know that I'll be picking up Aura at 6 o'clock.
And what happened with that?
I didn't get her.
And why not?
Because majority of the time, well, she said Aura's not in school, so she's not going by the school time to pick her up or getting her on Thursdays.
Okay, so tell me about the school. What was your understanding of the school?
My understanding was wherever she lives, even if she's in school or not, that she goes by the school that's around her.
Okay, and what time did you think the school around her got out?
4.
And why did you think that?
My wife and I called the school, and the lady at the front desk told us 4 o'clock was their dismissal time.
Objection, hearsay.
Sustain.
So you did some research,
Yes, ma'am.
and to the best of your knowledge, it was at 4?
Yes, ma'am.
Okay, and so if you turn to Exhibit 5, Exhibit 6 of respondents, Exhibit 7, all of those, if we go all the way through them, all the way to throughout the exhibit through Exhibit 9, those are all on Thursdays, correct?
Yes, ma'am.
And you're there around 4.
Yes, ma'am.
Okay, did you later find out that it was actually 3:15?
Yes, ma'am.
And how did you find that out?
We were in court.
Okay, so did mom ever tell you, hey, no, it's 3:15?
No, ma'am.
Was she ever there at 3:15? Where are you?
No, ma'am.
Did you ever, was there any communication about the time?
No, ma'am.
And so you showed up when you thought it was the time, correct?
Yes, ma'am.
And to your knowledge, did she ever show up?
No, ma'am.
And you were never able to get your daughter on those days?
No, ma'am.
Okay. And then, again, in Exhibit 10, that's the same thing, a Thursday. Is that correct?
Yes, ma'am.
Okay. And so you listed 13 violations throughout. Let's look at Exhibit 11 really fast.
Okay.
That one's actually on a Friday, not a Thursday, is that right?
Yes, ma'am.
And you're there at 5:57 p.m. to pick up your daughter?
Yes, ma'am.
And what happened then?
We were supposed to pick her up because that was first Friday, and it was the first Friday of the month, but the days kind of got shifted. But she said it wasn't.
So you said this is the first weekend in February,
Yes, ma'am.
and she said, take a look at your calendar and you'll see it's the first one.
Yes, ma'am.
Was it the first one?
No, ma'am.
So did you get to see your daughter that entire weekend?
No, ma'am.
Relevance, that's not a pleaded for objection.
Sustain.
Let's look at your requested summary of relief. Go to ours now. This is what you're asking the court to do today, is that right?
Yes, ma'am.
So you're asking, number one, that she's violated the possession and access order. Is that right?
Yes, ma'am.
You're asking for a suspended commitment. Why do you think that she's going to violate this again?
Because even with communication, it hasn't been good. So it's always back and forth, not communication on a positive note, but back and forth on another note.
Okay, so how many times have you not been able to see your daughter?
About 13.
Okay. And so you're just asking for her to be put on a suspended community service or commended community supervision for 5 years to make sure she continues to comply with these orders?
Yes, ma'am.
And you're also asking for your makeup days.
Yes, ma'am.
And that's what's most important to you, correct?
Yes, ma'am.
Okay. And so if you look at the calendar that's been previously marked P5, And I know it's not in color for you, but I know you've seen it in color, correct?
Yes, ma'am.
And then is that kind of just outlining the days that are yours and then the days you would like makeup days for?
Yes, ma'am.
And that would be if it had started tomorrow, correct?
Yes, ma'am.
Okay, and so you're just asking the court for makeup time?
Yes, ma'am.
And then, and everything else listed in here, that's also what you're asking, but your primary concern is just makeup time for your
Yes,
daughter?
ma'am. Makeup time.
Okay, and then you're also asking for attorney's fees, correct?
Yes, ma'am.
And you, and is there anything else you would like to ask the court today?
No, ma'am.
Okay, that's all the questions I have for you.
Okay, pass the witness. Counsel, pass the witness.
Oh, yes, pass the witness.
Okay, Attorney Granada.
Thank you. Mr. Slater, when did you first learn school let out at 3:15?
Oh, we're in court, after I filed for,
April of this year?
yes, ma'am. Sir.
And then you admit, I think when your lawyer was asking you questions, that on all of your alleged violations, you did not go to this, to the pickup location at 3:15, correct?
Yes, sir.
Okay, so you just admitted you didn't appear for any of these violations, right?
No.
You know, you don't. So if you just said you didn't appear at 3:15, then help me understand why you're now saying you didn't. You appeared. I'm trying to
I
understand.
never appeared at 3:15.
Okay, but you're trying to get her in trouble for not appearing at 3:15, right?
No,
What are you trying to get her in trouble
not sure, not giving me oral.
for? Okay, but the order says at the time school lets out, which is 3:15 for your admission. So how is she going to get in trouble?
That was after the court date.
And you learned in April, yet you're still going forward with your petition for enforcement today.
So,
You had learned that school got out at 3:15 in April of this year, yet you're still going forward with your petition for enforcement today
time.
for makeup time. Okay, for periods of time that you didn't show up at the proper time, right?
No, sir.
Okay, and you want attorney's fees today?
Yes, sir.
Okay, and you want suspended commitment, I believe you said?
Yes, sir.
Okay. Do you feel like your conduct would be a justification for the court assessing attorney's fees against you?
No, sir.
You don't think that you, by not showing up at the time school lets out, that this lawsuit is frivolous?
No, sir.
I'm gonna pass witness.
Okay, counsel, is there anything further from your client?
Just a couple. You showed up at the time of what you thought was when you were supposed to pick up your daughter, correct?
Yes, ma'am.
So even if you picked her up at 4, you still showed up
Yes, sir.
and no one was there.
Yes, ma'am.
And there was no communication of why.
Yes, ma'am.
And she never showed up at 3:15 either.
No, ma'am.
Okay, no further questions.
Okay,
So I don't understand why you're asking for makeup time if you're the one that didn't show up at the proper time.
Object, is that a question? Are we crossing again? Asked and answered?
overrule. Counsel, rephrase that question.
Mr. Slater, I don't understand why you're asking for makeup time if you admittedly didn't show up at the proper time to pick up your daughter.
Because I was there at 4.
But you're in the wrong. You didn't go at the proper time.
Not from what I was told.
Okay, but you understand the legal time is 3:15, not 4.
Sir.
You don't understand that?
No, sir. That's what I was told.
What time do you believe your possession starts now?
My possession starts now.
On Thursdays and Fridays?
On Thursdays after she gets out of school.
And what time's that?
That's around 3. Well, we get there early, so.
I'm gonna pass the witness.
Okay. Anything further?
Nothing further
No,
for this witness.
Okay, sir, you can have a seat back next to your attorney. Counsel, you may call your next witness.
I'll call Ms. Brooks.
Okay, Ms. Brooks, you may have a seat right here. Just make sure you pull the microphone close to you.
Okay.
Okay. And counsel, whenever you're ready.
Ms. Brooks, do you think it's in the best interest of your son to spend time with his dad?
I have a daughter.
Or daughter, I'm sorry, I have a son. I do that all the time. A daughter.
Yes.
Okay, and so you understand the court order?
Yes.
Okay. Did you show up on Thursdays?
Yes.
You did?
Yes.
And what did you do when you showed up?
Waited.
You did?
Yes.
Okay. And did you ask where he is?
No.
Okay. And so and he would text you at 4 the same days?
Yes.
And did you ever tell him, hey, I actually was there at 3?
No.
Okay. So you were intentionally trying to make sure that he didn't know the time.
No.
Okay. And you didn't give him to him on that weekend?
Not the days that he was late.
No, the day that he was on time
What day was that?
at 6 o'clock on Friday, when you said it wasn't even his weekend because it wasn't the calendar day. You remember that?
Yes, according to the order.
Like
he
it's
was
been an
supposed to be
objection,
there.
non-responsive.
Sustain after yes.
Thank you. So you never intended to let him see your daughter. You're making it difficult for him to see your daughter. Is that true?
No.
But you were there at 3:15. You didn't bother to say, hey, I'm here.
No.
No further questions.
Okay.
Can I add something to that?
No.
Your attorney is about that. Whatever needs to be cleared up, he'll do it.
Okay.
Okay, go ahead, counsel.
Yeah, I was gonna say, do you want to clarify the last question the opposing lawyer asking?
Go ahead, counsel. You may ask your question.
Yes, ma'am. Ms. Brooks, do you want to clarify anything in response to the question the opposing lawyer just asked you?
Can you repeat the question?
Yes, do you want to respond and clarify?
No, what question? Which one?
I'll move on.
Okay.
All right, so did you hear Mr. Slater say he never appeared at the time of his court-ordered possession begins?
Yes.
Okay, so we don't need to go through each text message showing he appeared at the wrong time because he just admitted it, right?
Yes.
All right. You've had to pay me a lot of money to defend this lawsuit.
Yes.
Not Ms. Caskey, but another lawyer working for him, when they did the initial filing, didn't even include the time necessary to get you in trouble, right?
Yes.
We had to ask the court granted our request to make him specifically state the time that you allegedly violated the order, right?
Correct.
They ended up actually, after court order amending, correct?
Yes.
Okay, and now we're here in court, I think it's like 7 months later after the filing, conducting a trial for alleged violations. He's admitted he didn't appear at the proper time for, right?
Yes.
Okay, what do you do for work?
I do DoorDash and I stay at home with my kids.
Okay, how old are you, ma'am?
26.
Okay, and how much do you make per year?
I'm not really sure. It varies.
Okay, is it well under 30,000?
Yes, sir.
Okay, is it under $20,000?
Yes, sir.
Do you know how much you paid me?
I would have to look it up, but it was a lot.
It's many thousands of dollars, right?
Yes.
We included some of your payments, which are $4,500 in our exhibits, right?
Correct.
And it's your understanding that more money is owed at this time?
Yes.
You're asking for him to pay your attorney's fees for bringing this, right?
Yes.
Do you believe the court's likely to deny his motion?
Yes.
Do you believe it's even close that the court will grant this motion?
No.
He came and admitted he didn't show up at the court ordered start time, right?
Yes.
Okay, he didn't even know that going into this. Is that correct?
Correct.
Meaning he filed a lawsuit against you seeking jail when he didn't even know the correct start time. Is that accurate?
Yes.
And has continued to refuse to drop it, right?
Yes.
They served discovery on you.
Yes.
We had to respond to that discovery.
Mm-hmm.
Part of that discovery was the school notification showing exactly when the school starts, when the school lets out, right?
Yes.
And Mr. Slater has still chosen to go forward with this lawsuit.
Yes.
You're asking for attorney's fees.
Yes.
This is real money you've had to pay, right?
Mm-hmm.
Out of your pocket.
Yes.
Have you borrowed money from anybody?
Yes.
Who'd you borrow money from?
My mother.
That's who you live with, right?
Correct.
And how much have you borrowed the entire amount from her?
Yes, majority.
She wants it back, right?
Yes.
That's real money you're gonna have to pay back to her.
Yes.
We conducted a phone call earlier this year, again, not with Ms. Caskey, but with another lawyer explaining the correct start time because he kept going at the wrong time, right?
Yes.
That was even after he.
I would object to that because that's
Judge,
I mean, I wasn't there, so then it's like hearsay on what we might have told her, like I wasn't there.
Well, she,
Well, he said it was another lawyer.
yeah, and she can testify what she said directly to him and his lawyer on the phone call. It's not settlement negotiations. We're telling them your client's going at the wrong time. So I don't think that falls under any objection.
Was she on the call?
Yeah, she
Yes,
was
I
on.
was.
Well, she can testify if she was on the call to what she said, not to what the attorney said.
Sure.
Okay, so overrule.
Did you, Ms. Brooks, I'm gonna re-ask the question. Did you tell Mr. Slater and the lawyer, school doesn't let out at 4, it's lets out at 3:15?
Correct.
Okay, you're going at the wrong time.
Yes, I did.
After that phone call, it got cleared up, right?
Yes.
You started going at the right time. After that phone call,
No, he didn't.
he still kept going at the wrong time?
Yes.
Okay. Is it your responsibility in the order to explain what his obligations are?
No.
Does that seem to be lost on Mr. Slater?
Yes.
Is this indicative of what you've been dealing with co-parenting wise?
Yes.
Okay. There's other issues about your daughter that you'd prefer no makeup time, right?
Yes, correct.
Is she acting out sexually at home?
Yes.
Section,
I'm gonna
What's
say,
your legal objection?
I guess relevance, we're here on an enforcement, not on best interest.
Thing.
you'd ask the court, not a mortar makeup time, right?
Yes.
Part of that is because it's his fault for going at the wrong time,
Correct.
not yours.
Yes. Can I also make a comment?
What do you want to make a comment about now?
She mentioned about me not telling him the times and communicating with him. But I just want to be clear that I tried communicating with him before at the very beginning and I got attacked every single time. And instead of answering the question or coming to a conclusion, I can show the messages.
Can you explain the difficulties you had?
Yes, anything I've tried to communicate with them as far as the meetup and everything, I have tried to talk to them. I just don't do it over and over. I did it once and then all I got was an argument. So I just stopped responding. Unless it had something to do with my daughter. And even if it had anything to do with my daughter, all I got was an argument or I got torn down by both of them in the text messages. It was never, they were never trying to come to a conclusion or a solution about anything.
You tried to work with him and his new.
Yes, multiple times I have. And they're saying I haven't and I have. And it's not my fault that he did not know the time.
This is kind of consistent. Is his behavior consistent with the conduct during this lawsuit that he's taking no responsibility for what he should be responsible for?
Yes, yes,
Been very,
no responsibility.
it's been very,
And it's not my fault.
is it difficult? It has been difficult to deal with Mr. Slater?
Yes, very difficult. I try my best. It's very difficult.
Judge, I'm gonna pass it.
Okay. You said you tried to communicate with him. Let's go through these exhibits.
Of course.
Exhibit 1,
Mm-hmm.
he says, I'm here. Do you respond?
No.
Okay, exhibit 2.
Hold on one second. We're referring to dad's exhibits?
Yes.
Okay, go ahead.
I don't have that as
Yeah, let me-
exhibits.
Oh, did you take them?
Yeah, he did.
Sorry, may I approach?
Yes.
Just FYI, those are our exhibits, so.
Yes.
Okay, he said dad exhibit. Okay.
So which one?
This one.
Okay, this is same one.
Yeah, so
It's
just
the same
pick
one?
file. and
Okay,
then-
yeah,
There you go.
okay.
There you go.
Okay, so you don't respond in exhibit 1.
Yes, exhibit 1.
Let's go to exhibit 4. You don't respond.
I did respond to exhibit 4 and he did get his daughter an exhibit 4 and he said previously he did not. but he
Okay,
did.
let's go to exhibit 5.
Okay,
Did you respond?
no,
Okay, let's go to exhibit 6. Did you respond?
no,
Okay, let's go to exhibit 7. Did you respond?
no.
Okay, so do you think that you understand that he did his due diligence and he thought it was at 4, correct?
I want to mention that the.
Objection, non-responsive,
Sustain.
yes or no? You heard that in court just now. He did his due diligence, he thought it was at 4. You heard that, correct?
Yes, he had the wrong time.
Okay, but you understand he didn't know that at the time. He did his due diligence to his understanding.
I believe he did know.
So is it just now that you're saying you showed up at 3:15 after this order was initiated?
No. And
Okay, objection, non-responsive. Or
Was she?
she said no. That's all I want.
Yeah, that was that. Overruled. That was the answer.
can I add to that?
No, she'll ask the next question.
Okay.
Exhibit 8, Exhibit 9. Do you respond?
No.
Okay. Do you think if you would have responded, this would have been here today?
Can you say that again?
If you would have just told him it was at 3:15 and you were there at 3:15, do you think he would have filed this lawsuit against you?
Probably.
Okay. And so was it your intention just to show up at 3:15 and never let him see the child on Thursdays?
No, it was my intention to show up at the right time. And if he can,
Objection, non-responsive, strike everything after no.
Sustain.
It's actually you, the one that can't communicate, is that right?
no.
And after you did communicate, he showed up on time.
Judge, I'm gonna object as relevance. I mean, on the scope of what we're here for, this is way beyond.
I think it is relevant because I think the violation is the court order and what they knew at the time and what their intent was. And her intent was to violate the court order and not let him see his child.
I'm going to sustain the objection and I get it.
Yeah, okay, thank you.
Okay.
No further questions.
All right, counsel.
Yes, ma'am, do you believe you can get in trouble for appearing at a time that you weren't ordered to appear at?
No.
Okay, that seems to be the entire theory of Mr. Slater's case, right?
Yes.
Okay.
And can I add something to that,
What would you
please?
like to?
Yes, she's mentioning things from November, but the order started in June and we were having problems way before then with communication. And so I tried to limit the
Objection,
communication. No, there's no,
I think she's opened the door that my client can explain prior.
Well, not narrative.
Okay, yes, ma'am. I'll pass the witness.
Anything further from this witness?
Nothing further.
Okay, ma'am, the text message that you were just looking at, the December 19th date,
what number was that?
let me go back. It is December, hold on.
I think two.
I mean, exhibit. Hold on, I think I shrunk it. Exhibit 2.
Yes.
Is that you that sent the highlighted portion?
No.
That was
That's him. Okay,
Mm-hmm.
trying to abide by the court order.
okay. Hold on 1 second. Let me. Okay, so you're in blue.
Yeah,
Yes.
Okay.
Yeah, it's in black and white for me.
And at the time of this December 19th, was the pickup time at 6 p.m. or was it when school got out?
It's still when school got out.
Okay.
Let's step up.
Was she getting out early?
My daughter was 3 years old at the time, so she wasn't in school. So we were following the school that was closest to our home, or supposed to be.
Did they have pickup early or something that day? Or early dismissal because it was the holiday? Because I'm reading his message and it said, I will be at the designated location as specified in the court order tomorrow, Friday, December 20th at 12 o'clock noon. So I'm asking the school that is closest to your house, did they have early dismissal or something for him to think it was at noon?
Your Honor, I think the prior step-up order had him getting, was it a Saturday or a Friday? Because he was at noon on Saturdays.
Oh, this is 24. That's right.
Okay, I think
and
that,
December 20th is not an alleged violation. The reason we included this is to show that the alleged violation is on December 19th. And so there's text messages on December 19th clearly showing he didn't show up at 3:15. They're talking about a different topic. It collaterally establishes that he didn't appear at 3:15. But it is discussing December 20th. That is correct.
Okay, that's where my confusion
Yeah.
was, because the dates don't match, the dates that are in the violation don't match up with the text messages.
Yeah,
That's where the
That-
confusion came from me.
that's the one confusing one that's why we included it, because we think it shows, no, he didn't show up at 3:15.
Okay, So your daughter, does she go to daycare or she's with you?
My daughter's homeschooled.
Okay. And she gets out of homeschool following the school schedule that's supposed to see your house at 3:15.
Yes, at the time it was 3:15.
All right. Okay. What is it now?
It's 3:25 now.
And because you're homeschooling, you all are still doing pickups at the Dallas Police Department?
Yes.
All right. That's what I needed to know. Thank you.
I guess I have one question.
Go ahead.
Just, we didn't really cover it. You feel like the entire motion also fails because if you flip to exhibits 1, he was supposed to do 6 months of stair-stepped custom visitation, and he would get an SPO, right?
Correct.
And he missed a weekend
Yes.
during the 6 months.
Yes.
So ostensibly, he doesn't even have SPO right now.
Correct.
Because the order doesn't cover what happens if he misses a weekend, right?
Yes.
And exhibit 1 is him going late and not getting her for his weekend, right?
Correct.
It's not an alleged violation that he's alleging, correct?
Mm-hmm.
You're saying you missed the entire weekend during your 6-month step up.
Mm-hmm.
So SPO ostensibly doesn't even apply, right? And there's no provisions. Does the 6-month reset? Is it just a makeup? When is the date starting for SPO? Does he even have SPO if he misses time,
I
correct?
would object to this, because this is all legally questions that she wouldn't really have a fair understanding to
Fine.
answer this whole line of questioning.
Thing.
I'll pass the witness.
Anything further from this witness?
Nothing further.
Can I
Okay.
add something?
Ma'am, you may have a seat right there.
Okay.
Counsel, you may call your next witness.
I just call myself for attorney's fees.
Okay, go ahead.
Okay, we can stipulate? Okay, perfect. So we're stipulating to credentials, Your Honor. Our attorney rates at our office are $400 an hour. My rate is $300 an hour. Our associate attorney's rate is, or our law clerks and paralegals are $200 an hour. We spent approximately $4,200 on this hearing. And preparing for this hearing, we had to prepare discovery, prepare exhibits, file our petition, show up to multiple courts. Hearings, the April hearing was reset not due to anybody, but due to, I think, unavailability that day. So it wasn't a fault to anybody else that were here today and not in April, because we were ready to go in April as well. We drafted the original motion for enforcement, discovery, prepping for the enforcement hearing, reviewing, and then just anticipated fees. So that's a total of $4,200 that we're asking the respondent to pay at this time. And that's it.
Thank you. Any cross?
No, ma'am.
Okay.
And I rest.
Okay, counsel?
Yeah, sorry, I'd call myself.
Okay, go ahead.
Judge, I have exhibit 13, which is a summary of my credentials, the time spent on this case, my hourly rates, and just kind of qualifies me as an expert. And I think it's already been admitted, but I'd ask you to look at exhibit 13 if you have questions about qualifications. Really, I'd like to testify why you should give Ms. Slater fees. Judge, may I approach the bench? I have a proposed order.
With the affidavit?
No, with the proposed order.
Oh, okay.
This case should have never been brought. It's very clear.
And there's your jump drive back. Your jump drive.
Oh, thank you.
You're welcome.
This case never should have been brought. It's very clear. Mr. Slater has had many, many months to realize he doesn't have a case because he didn't go at the correct time. We've pointed it out to Mr. Slater numerous times. It's been hearing after hearing, appearance after appearance, discovery, answering discovery. Miss Brooks lives at home with her mother. She's in her 20s. This is real money that's costing her and the child. We'd ask you to assess attorney's fees against Mr. Slater. I don't believe it's even close that this should be granted, since the first thing he said when he took the stand is he admitted he didn't appear at the correct time. It appears he made no effort to figure out if he was appearing at the correct time. And it feels like the world, according to Mr. Slater, is Mr. Slater's world and everybody just kind of conforms to it. Well, that's not how it works when you have a custody order. He's supposed to appear at the correct time. The evidence has been overwhelmingly clear. He didn't. He's known about it for months, and yet still here we are going forward with this hearing. I think fees are more than justified against Mr. Slater and the amount in the proposed order. Thank you.
Thank you, counsel. Any cross?
No cross. I would like to do a quick closing
Okay.
minute.
If you think it's necessary.
Yeah, just a minute. So, obviously, as you heard, he did follow the court order to the best of his ability. At the time, he believed that it was 4 o'clock. He called it, he did his research. He thought it was at 4. He showed up at 4 every single time, trying to abide by the order, trying to do the right thing, sending the court order to her. In response, Ms. Brooks did not communicate, did not respond, did not have any intention to ever follow this court order, and that needs to be addressed. He is a father. And then, I'm more concerned today hearing, again, new allegations. I think this is the very start of this, and this could go down a very dangerous path if mom is allowed to continue to not communicate and isolate dad, which is what I believe she's trying to do and what the evidence shows. Thank you.
Thank you.
I think we have an order on file, Your Honor, and I apologize that I don't have it printed off for you.
Okay, thank you. Counsel?
Yeah, I have nothing, Judge. I'll
Okay.
rest and close.
Hmm. You both understand that enforcement motions are very serious, right? I'm talking to mom and dad.
Yes, ma'am.
Y'all understand that, right? And they become even more difficult when they're not followed for trivial reasons, right? And what do I mean by trivial? Unless your daughter is in danger and there is a danger that you know at the time, everybody should follow the court order to the best of their ability. Counsel, I have one question for you. To your knowledge, did she have a conversation with Attorney Faust about the time that the child gets out of school?
No, not to my knowledge.
Okay, so you don't know if it happened.
No, but to my knowledge, after he realized it was 3:15, I know there was testimony opposed to that, but he's been showing up at 3:15 ever since he learned.
And learned.
Okay, oh, and let me say this before we go any further. The order is silent about what happened if he missed any visits or anything like that, and the court is going to go by the order in strict compliance with it. Do you all live within 50 miles of each other?
No, I don't believe so.
Yes, we do.
Yeah, where you live?
Mesquite.
Where do you live?
Corny.
Yeah, you all live within 50 miles. So,
Oh, I thought you said.
no. So the court order already tells you exactly what you're supposed to do right now. So because I don't want either one of you walking out of here not knowing what your court order says. It specifically says that if you all live within a 50-mile radius of each other, it outlines what your possession and access is supposed to be every week. It's on, well, this order isn't numbered, but it says parents who reside within 50 miles or less, except otherwise explicitly provided, if Matthew Lee Slater resides 50 miles or less from the primary residence of the child, the parent shall have the rights and possession of the child as follows, and it outlines that you've seen it, you know what it looked like. So, it starts when school regularly dismisses.
Yeah.
Right? Ma'am, what time does school regularly dismiss?
The new school is 3:25.
3:25, so you have that.
Yes, ma'am.
Are you all confused about where you're supposed to exchange?
Yes, I do want to make a comment because we're supposed to meet at the police station,
Yes.
but they like to walk up to my car, and I told them before I don't feel comfortable with that, and they keep doing it instead of letting us meet inside of the designated area. They keep trying to walk up on me, and I don't like that. I don't feel comfortable.
Okay, so the
So can we
order
make sure that
doesn't,
it's on the inside and not around my car. Like,
okay,
walking up
so
to my
this
car.
order, it doesn't explicitly state. It just says the Dallas Police Department. If she's saying she doesn't feel comfortable with you walking up to the car, just don't walk up to her car.
Yes, ma'am. We actually wait on the inside. She wait until like minutes after the transfer time, still calling her back in the car and
Mhm.
holding on to her and stuff. So we walk outside of the police station and let her know, hey, we're out here. What are you doing? Let's go. You know what I'm saying? Don't let
Y'all just exchange in the lobby.
Yeah.
Just make it
Yeah.
easy. Exchange in the lobby, because if you're in the lobby, there are cameras and there are police officers there. But so if anything transpires, I'm going to know for sure who did what,
Right.
and there is no discrepancy. All right. The reason that and let me just say, I don't think that either. When was the last time you seen your daughter?
This past Thursday.
Okay. So I don't think that Mr. Slater intentionally did not comply with the order. And I know that I don't believe you did it intentionally, because if you did, you wouldn't have given the testimony that you did. Your testimony was honest. I honestly believe that whatever conversation between you and your attorney, you were not advised 100% about what this order actually says, okay? And because of that, and because this order, the way that it is written, the law says that it has to be in strict compliance with the violations. If there is no strict compliance, I cannot hold her in contempt. And I also cannot find that she violated this court order. Does that make sense?
Yeah.
So with that being said, I cannot find that she violated the court order. I'm not going to say that you shouldn't have brought the order, just like I wouldn't tell you not to bring the order. Okay, I don't need that, counsel. I don't need that. Just like I'm not going to tell you not to bring an order. I'm not going to tell either one of you to do that, because if either one of you are not following the court order, whether it's possession and access or child support, you do need to bring that to the court's attention. So I don't want anybody to be discouraged. So I'm not going to find her in contempt. I cannot find her in contempt. I cannot find that she violated the order, because the way that this motion is written, it doesn't allow me to do so. All right. With that being said, just follow the court order. If you all follow the court order as is written to the best of your ability as is written, that's all you're responsible for. Anything that's not enforceable, you have attorneys to bring that to my attention, and there are things that I can do to do that. And because the order is not, because the motion is not specific the way that it needs to be, I think awarding attorney's fees to mom would be punitive to dad. And I don't believe that's fair. So each person is gonna walk away today paying their own attorney's fees. They know what their responsibilities are under the court order. If you all come back in here moving forward, then I know that we're gonna have an issue, because I just explained it to you. You understand what the order says. Do you have any questions for me, Mom?
Yes.
Go ahead.
So he was on the phone call and he still came at the wrong time. I just have questions, because it seems like he's able to make numerous mistakes all the time, and he's never held accountable, but it's always making me look like the bad person. When he was on the phone, he got the exact time. She was on the phone too, the lady in the green. She was also on the phone. They got the time, and they still showed up at the wrong time. And this was after the court date. They were still appearing at the wrong time, and I even told them that.
Yeah, but let me say something to you. He didn't make you look bad today. Neither one of you look bad. And let me explain something to you. Y'all are parents. I have 2 kids. I have a 16-year-old and a 16-year-old. I get it wrong every single day. Every day. I'm still trying to figure out parenting. It's not easy at all. You're always going to make a mistake. You are always going to get it wrong. I don't want either one of y'all to walk out of here and think that you're going to get it right. Judge or no judge, I still mess up. And I'm still figuring out. Is it Aura? Aura is 4 years old. Y'all had the rest of y'all life to figure it out. And even figuring it out, you're still gonna get it wrong. Okay? So I don't want you to walk out of here and think that I'm looking at you a certain type of way. I look at you as a parent, as I'm a parent. I look at you like I'm a parent. I don't look at you any other way, okay? Legally, there are things I can and cannot do. All I want you all to do is, when you walk out of here today, learn how to co-parent, because I kid you not, y'all are going to need each other more than ever. And you only gonna have each other to depend on. I know you have your mom, you have the support of your family. Huh? Your wife, you have the support of family, both of you. But at the end of the day, the mistakes and the things that are done right are gonna fall back on the parents. And that's what I want y'all to do. I want y'all to work together and be good parents. If you can't figure it out, that's what I'm here for. But I don't want to do anything to either one of you today that's going to be punitive. I don't think that's fair. So you each pay your own attorney's fees. Is there anything further?
Hey, Judge, if you strike the bottom two paragraphs, the order denying, the bottom two paragraphs have to do with my attorney's fees, so I think if you cross those out, I think we can walk out of here with an order.
Okay. Did you e-file this?
I'm pretty sure I did.
Okay, let me double check. Because if you e-filed it, it'll probably be cleaner
Okay.
if I do it on,
It would have been my paralegal.
yeah, I'll just do the order. It'll be short.
Okay.
So I'm signing the order today, denying anything. Wait a minute, I asked her, did you have any questions for me?
Not really questions, but in the whole point of it, just wanted to, the time back of dealing with, or my wife and I just want a good co-parenting thing. We don't have to be friends or anything, but communication is one of the main things, you know what I'm saying? Figuring out what's best for Aura and how we gonna do this, you know what I'm saying? So that's the only part when, once when I filed, then we start getting the right time on when we were supposed to pick up Aura, and then, we start getting her on Thursdays. We was cool with that because it's there. But getting that back time, of course, we needed that because I've already been strict with her and everything like that.
So because I denied the motion in its entirety, because of the violation, the way that the violations are written, I can't even award back time. But you know what? We're gonna move forward, because moving forward, you're gonna pick up when you're supposed to pick up, you know the time. You're gonna exchange when you're supposed to exchange, you know the time, and y'all gonna do it in the lobby, remember? Don't go to each other's cars, just do it in the lobby. Okay? Do either of you have a question for me before you walk out of here? I wanna make sure everybody is on the same page. Now's the time to ask.
And then there's also, what can I? CPS charges.
Be a moment. Let me get this going. Yeah.
Anything else about the order itself? No? Okay.
Are we allowed, since she?
Ask the question. I don't want anybody to walk out of here confused.
Yeah, ask her. She's giving you a chance.
No, it's fine. I just say report modification.
Okay. And you all can do that. You know you can modify the order as much as you need to.
Yes, ma'am.
Okay. Y'all have a good day.
Thank you.
You're welcome. All right.
Thank you, Your Honor.
You're welcome. All right. Good morning.
Morning, Jeff.
DF 2402257. Ronaldo Padilla and Doyleta Minix. Hey. Okay. All right. All right. So on my Zoom, good morning, everybody on my Zoom. Oh, the camera right here. DF 2014623 Owens.
Good morning, Your Honor.
Good morning.
Good morning, Judge.
Morning.
Okay, so I see Catherine, Attorney Ernest. Do I see Daniel Owens? I don't see Mr. Owens. Is he represented by an attorney?
He is not judge, and I am willing to bet he is logged in under Judge Lee's number from last week. So I've asked the legal assistant to call him and tell him or confirm the code with him, because he said that nothing was going on.
I heard you. He's switching now. I see him.
Great.
Okay. And then DF 2410679 Richardson.
Yes, Your Honor.
Good morning, counsel.
Good morning.
I see your client We're missing Troy Richardson.
They're here.
Oh, there. Oh, how you doing?
I'm good, Judge. I thought we were in person. I apologize.
No problem. Is there a room open, one of those conference rooms? So you all can step in there and jump on Zoom?
I bet we can figure it out.
Okay, perfect.
Do I have about 5 minutes, you think?
Yeah, go
Thank
ahead. Yeah. Yeah, no rush. And you all are here on Padilla and Minix?
Yeah.
Okay. All right. Okay. Did he come back? Yeah, it is right now. It still shows the icon. Okay, yeah. Are you all's clients here?
You talking to me, Your Honor?
Your Honor, she is pro se petitioner.
Oh, I see. Okay, he's on here.
He's on there, Judge, and I don't know if are you taking us, Judge, or you're taking the Zoom people? Whichever
Well,
you
yeah,
wanna
both
do.
of y'all are on Zoom. Mr. Ronaldo is right here.
He's on Zoom, Judge. We were in person, so I don't know if you're gonna count his presence for the contempt of being here on Zoom. He's in Alaska.
Sir, why aren't you present in the courtroom? Mr. Padilla,
I think he's trying to figure out how to
let me,
unmute.
I asked you to unmute. I sent you a prompt.
Your Honor,
Good morning.
I have good morning.
Good
I
morning.
have fear of flying due to we think is PTSD and the doctors know, but I believe I sent it in a little too late.
Yeah, and that's not sufficient, because you were actually ordered to reappear. And I'm assuming your attorney told you that.
Yes, ma'am.
Okay, and we've already done a KPS in this case before.
Judge, I think maybe a year ago, it's prior to us being on it. So
Yeah, well, I know that. I know that. You have another KPS?
No, not yet. I was waiting for your.
Okay, I'm going to issue another KPS.
Your Honor, I explained to my client that that was a high possibility of that. This case is pretty old and I think as it was set, you'd say this is the last one. Ms. Minix has asked for other relief judgment wise, so I don't know if the court wants to go forward on that so she can at least do that and finish it. Am I saying that correctly?
Yes.
Pronounce it.
Miss.
Minix.
Yes.
Okay.
What relief are you seeking?
So all the court order, order, the relief on my son's, the court orders, he's supposed to pay school tuition for my one son. Medical, he's supposed to pay 50% of extracurricular activities and 50% of unreimbursed medical and dental expenses. And this is all in the current court orders.
Right. So those are what she said, what would stop me from issuing a KPS?
Judge, nothing's stopping you from issuing a
Okay.
case. I was just saying if the court still wants to do the judgment parts. As I said, I explained to my client that that was like, the court may likely issue a KPS as he was ordered to be here in person.
Yes, he was ordered to be here in person. Sir, I'm going to issue a KPS warrant for your arrest. When I swore you in back what was it, back in April or June, it was made very clear that you were supposed to be in person, and to try to send something into the court to get out of that, that's unacceptable. Yes, I swore you in June 23rd, 2025. So if you give me a KPS, we're gonna reset it. And I know you know, if, when we do the KPS, it means that you have to come back. Okay? Now you can waive the KPS. I mean, I've done the KPS before, so he's aware of what his responsibilities are, and he has counsel who has told him that. So it's really up to you. You could choose to waive it and you can proceed. If this were a situation where the child was being restricted, I could see that. But if we're just talking about the payments of fees, that's really going to be a judgment call up to you.
So what you're saying, just so I understand, because I don't understand all the legal stuff. You're saying if I go get a KPS and issue a KPS and bring it back to you, you're gonna issue a warrant out for his arrest?
Correct.
Based on what you had ordered him last year and then the summer?
Correct.
Correct. And then you're saying, then we will come back and continue this?
Correct.
And then my totals and everything can continue to update?
Yes, ma'am.
Then I think that's the appropriate thing to do today.
Okay. So
And where do I go?
Your Honor,
go ahead.
well, Judge, I think you can technically do both. I think you can issue the KPS and he's not here, the court counts it as a default, but to have the hearing on the money issues, and that does not keep the KPS out. You just can't be held in, he can't be held in contempt, as you know, Judge, since he's not.
Correct. And
Here.
and that defeats the purpose.
I'm sorry, explain that to me.
The contempt part of it, he's not here. So in order to hold him in contempt, he has to physically be present.
So in contempt to these filings on what he owes, or you're saying in contempt for showing up?
Well, he's already in contempt for not showing up. Yeah.
Okay, so you're saying I would strike that, and if I go?
No. So bottom line is this: if you choose to move forward today, you can. I can issue the KPS. I wouldn't prefer to do it like that, because you'll have a hearing today, and then we'll have to end up coming back anyway once he gets arrested. Because after someone gets arrested on a KPS, they have so many days that they have to come before me, and then I reset the date for them. I swear them in to reappear on a subsequent date. So I'm going to have to do that anyway.
Okay, to reissue a case that he has to appear in person.
Correct.
And that would have to make sure that we're both of it. Okay. I see.
Yeah, and I just think it's cleaner
And then-
to do it that way instead of having a hearing today.
And then when I ask if you issue a KPS, if we issue a KPS out for his arrest, do they arrest him in Alaska and bring him back to Texas? I don't understand. Do they arrest him in Alaska?
Sir, how long are you in Alaska?
The least amount of time as possible. I'm trying to figure out a way to acquire a job in Texas.
You know, that, I believe that's been his residence for some time now. That's where family is. So that's where he had to go for family.
I mean, I understand that, but you do
I didn't have
understand.
medical care. I didn't have medical care in Texas. And in
And-
Alaska, I had free medical care so I could address the mental health from the
The-
assaults.
The issue is that you're ordered to appear here, regardless to where your residency is. You were ordered to appear here. You got that?
Yes, ma'am.
Okay. So yes, the law. If you go to the law library,
Yeah.
they'll be able to get you the paperwork you need for the KPS.
Okay. And Judge, on that note, I do need to understand, and I believe is the Office of Attorney General on the call?
Are they on this case? I don't know.
They are, they intervene.
Judge.
Yes.
Oh,
ma'am.
okay.
Yes, Judge. Franklin present with the Office of Attorney General.
How are you?
I'm doing well, Judge.
Good. Do you have a question for her? That's Attorney Franklin.
In the third box, maybe it's the third box.
You
Is
see
the
her?
box the same at the top?
Which one? Oh, Alina. You might pronounce it. I guess my question, sorry. You don't know the physical address because he has not provided anything that the OAG or that he's been court ordered to.
Well, no one from Texas is going to Alaska to get him.
Okay, so then,
He would have to be here and get arrested.
okay. Okay,
So that's why I said in the beginning, it's really up to you how you would want to do it. I would be inclined to issue a
Would-
KPS just because he didn't show up to court after he was ordered to appear to do so.
how are we ever gonna know when he reappears? He's supposed to, by court orders, identify where and where he lives and notify everybody that has court ordered him.
Well, that's
No,
irrelevant at this point because when I swore him back in, he was ordered to appear.
Right, so then when he appears on this next KPS, so he's got 30 days, you're saying? He'll have 30 days and then he has to reappear?
No,
Here?
no, it doesn't work like that.
I'm sorry, so.
Yeah,
it's-
it doesn't work like that. So a KPS, it'll just sit there until it is satisfied, which means until he gets arrested, the KPS warrant would just be out on the computer until he is in Texas borders and they can exercise the issuance. So I issued a KPS. When the KPS is satisfied, meaning when he's arrested, then they will send notification to the court to let us know that that KPS warrant has been satisfied.
Okay. Thank you. And then for today's purposes, you're saying we could still proceed with some things? I was confused.
You absolutely can. You can, I mean, if you say, like I said, I'm inclined to issue a KPS because he didn't show up.
No.
However, if you say, Judge, I'm okay with waiving issuance of the KPS, I would like to move forward today, you absolutely can do that. It's clear though, he's in violation of the court's order. Does that make sense?
Yeah.
Okay.
So if I understand, I just want to make sure that I understand. So I'll get that KPS issued, but I still want to present what we owe. what
You
he
can do
owes.
this. Yes.
Okay, and we can move forward and then.
Yes,
I'll
ma'am.
bring you the KPS back here.
Yes.
You.
Yes.
In court.
Yes, ma'am.
Okay, and who do I hand that to? So I'll go.
You just give it to my bailiff.
Okay.
Yeah.
Thank you.
But you can do it after we do this part of
And
it.
I'm gonna take care of everything while I'm here today,
Okay.
since I have to take the day off of work.
Okay.
Thank you, ma'am.
You're welcome. Attorney Franklin, did you have anything?
No, Judge, we did file an intervention. Our issues only concern the conservatorship and support though, but I do know Mom, I don't know if she had questions on any child support arrears that were owed. But we didn't have an intervention as far as any enforcement action.
Okay.
No, I didn't. have a-
Judge Lee found they didn't have any relief requested when we did the exhibit conference.
Mhm.
They weren't there, and she looked and said, well, they didn't ask for any relief.
Who, the OAG?
OAG, so they weren't really, I guess, essential at this point, was her point?
State, what is it that you all are looking for today?
So the state didn't have anything on the pleadings today, Your Honor, because we did not file anything in our intervention concerning child support arrears or judgments on any of that.
Okay.
And I don't know, just for clarification for Mom, because I mean, reading her motion, I don't think, if I'm correct, she didn't request any relief as far as child support arrears, so nothing concerned us on this case today.
Okay. Did you understand what she said?
Yeah, I mean, yes, I know he's court ordered to pay child support,
Yes.
but in the relief, it wasn't in the release because this has been going on. And if you go back to look at your court orders, Judge, that you signed, the requirement for child support was put in July of 2024.
Right.
So
But do you understand what she's saying?
Yeah, so she hasn't done that. The only thing they did is they e-served Miss Parker on financials, trying to obtain financials, address other information from her client. And to my knowledge, have we ever received those court orders? And Miss Franklin, did the OAG ever obtain what you had served Miss Katrina on behalf of her client?
No, you mean financials as far as his pay information?
Yeah, everything that you served Miss Katrina with.
No,
Payment.
we haven't.
Records, IRS, as you know, U2s, taxes, Social Security, location, address? Have you
No,
received?
we don't have any documentation for Mr. Padilla.
So you haven't received any documents from Miss Katrina?
No,
On behalf of her client?
no.
Okay,
The only exhibits that, so state, before I ask this question, do you have any other cases that you're here on this morning?
Yes, Judge, it's I believe Owens matter.
Owens, okay. Thank you. Okay. So the state is relieved from this. Can I have that?
I think so.
Okay. So state, you'll just hang tight for the next
Okay.
case.
Okay, Judge.
Thank you. I don't know why I can't see this.
Judge, I think there were two cases, Your Honor, and that could be part of the issue.
They were consolidated?
They were consolidated
Okay.
at some midpoint. And so that was confusing for me as well.
Okay, so that's why I can't see.
Is that why? Okay.
Yeah, but it's not on here at all. It may be under that other case number and it just wasn't moved over.
But we got a certified copy the other day, Judge. You can see on the back. So that's from the clerks.
Okay, so this is hold on. So this motion was filed under the consolidated case, which is closed. That's why I couldn't
okay.
find it. Yes. So it should have the case number of 24. Okay, I found it. All right. So ma'am, the only request that you made for today are the confirmation of arrearages for the school tuition, extracurricular activities, and healthcare expenses.
and attorney fees.
That's the one I said that.
Yeah, and attorney's fees.
So school tuition. Extracurricular activities, correct? Unreimbursed healthcare expenses, as well as attorney fees. Yes, ma'am.
Okay,
Yes, Judge.
all right. Okay, so I'll be flipping back and forth between both case numbers because the motion is in the old case.
Yes.
All right, Mr. Padilla, we're gonna go ahead and get started with today's hearing. Attorney Parker, did you submit any exhibits?
Your Honor, we have one exhibit that we gave to Judge Lee. I don't know. I sent it this morning. I was gonna send to Ms. Rivera as well, but I didn't know. Judge Lee said she was sending, so I didn't know if that was proper for me to send to her.
Okay, I have primary care provider note,
Yes, Judge. I think that's it.
and there was no objection to this?
Judge, I think she objected on, I forgot what basis, and Judge Lee said on that basis, it's admitted.
Okay. All right. Are you all ready to proceed?
Do you need that, Mr. Fair?
No, I've got the primary care provider note, but do you have one?
1, 2, and 3?
I've got,
Well, it's 3 emails.
Oh, wait.
I've got 1, 2, 6, 7, 8, 9, 10, 11, and 15.
Yeah.
Oh, wait, I don't know which ones.
Yeah, I have all of them. You
I
have 1
think
through
the others were, Judge told us to send in what we objected to, what we had issue with. And I think the others were stipulated. The ones you're missing probably is what's going on.
The ones that are missing are not stipulated.
No, ones that were missing were stipulated. Well, what do you, I'm sorry, tell me again.
1, 2, 6, 7, 8, 9, 10, 11. Were those the ones stipulated too?
That's what Judge Lee ruled on several of those. Some were, yeah.
Those are the ones I have.
Okay, let me tell you what I have. I have a couple of different ones. So I have W7, W7, W9, W8, W10, W11. And then I have W2, W2, W6, W1, W15, and a copy of W11.
I guess the only thing is if we have a 1 and a 2, does that, because that's,
I have two number twos though.
okay, one is your statement of requested relief.
So one of the number twos is the Rule 11 agreement. And then the other one is the Rule 11 agreement modified.
And they may go beyond that,
They're
Judge, if
all-
you scroll, it's a lot in there.
It was basically getting Ms. Parker up to speed, just so she understood all the court orders on what he.
We just need to know
Yeah,
Yeah, we,
one and two are,
which one of two,
To,
which one of two do you want?
starting with Rule 11 agreement for temporary orders all the way through, page, let's see. One second, Ms. Parker,
No, it-
through page. That's probably it. You want me to count them? Sorry.
No.
And then what, it's, okay, and what's the other W2? You'll take the larger of the two is what I submitted. I submitted both, waiting to hear.
long as you have it. Okay, so what are the numbers? So I can say it on the record. No, numbers.
W.
And what else? Because I have 7, 8, 9.
Yeah.
No, it's 1, 2, and then for Judge Lee,
Wait. Oh, go ahead. When did you, what is that?
did you get the email this morning? It's what she.
No,
put in
ma'am.
and What she did.
No, when was this sent?
Mm-hmm,
Do you know when this was sent?
this
Sorry.
morning.
At what time?
After,
After, like, we arrived at?
no, before we got here. That's what she sent them.
Well, okay, I did not see that email. I apologize. So I just came with everything today, assuming my exhibits 1 through 17 were gonna be approved since I had not heard back when I pulled in the parking lot and got packed and came up here. So do you know what time she sent those? I'm
About
sorry.
9.
Oh, yes, sorry, Judge.
Actually, no, not 9, I'm sorry. It could have, not 8:30.
Yeah,
between
sorry,
8:30.
Judge, I apologize. Missed it. I was packing and already.
No, it's fine.
So does
So I don't
W
understand-
have a second page? Cause I only have one page of W1, this one.
Okay,
so Mr.
W1
Mayor,
does.
I have 1, 2, W1, W2,
Let me,
and
let-
W6,
Mhm.
W7, W8, W9, W10, W11, and W15.
Okay, that's what I have.
Yes.
let me.
Two W7s, let me see what.
There are two W7s, two
It's
W2s.
cute, it was too big, it's, all of that's one.
Okay,
They are all one.
so it's 1, 2, 6, 7, 8, 9, 10, 11, 15.
Wait, I just, one, can you read
Mhm.
that off again?
1, 2, 6, 7, 8, 9, 10, 11, 15.
And Judge W6, she said was as a summary only.
Okay, so technically it wouldn't be an exhibit.
She could have admitted as summary.
Okay,
Well,
And Your Honor, just to clarify, since Mr. Padilla we're not going forward on contempt today since he is not present in the court.
correct.
Correct, all right.
All right, Mr. Padilla, are you ready to proceed?
Yes, ma'am.
Okay. Ms. Minix, are you ready to proceed?
yes, ma'am.
All right. Joy, you ready? We're on the record in cause number DF 2402257. Counsel, will you please announce for the record?
Your Honor, Katrina Parker, Dallas County Public Defender's Office, we represent Respondent Reynaldo Padilla.
Thank you. And ma'am, would you please announce for the record?
Deletta Minix, and I am pro se.
Okay, and you're the moving in this case, is that correct?
Correct.
All right, with those who intend to testify, please raise your right hand. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Thank you. The court just needs the record to reflect that Mr. Padilla was sworn to appear in person back on June 23rd, 2025. He has failed to appear here in the courtroom. In the physical courtroom, he's actually present in the courtroom on the Zoom, identified as Renato Padilla, cause number DF 2402257. We're here today on a reset for a motion for enforcement that was filed by Ms. Minix. And the court appointed the Public Defender's Office Attorney Parker to represent Mr. Padilla. Ma'am, are you ready to proceed at this point?
Yes.
All right. You all have 15 minutes per side. That will include any open and closing statements should you choose to make one. And then I also want to admit the exhibits that were previously admitted. Movements exhibits 1, 2, 7, 8, 9, 10, 11, and 15 are admitted. Movements exhibit 6 is actually a summary of requested relief. And then on respondent, we have respondents exhibit 1 that is also admitted. All right, ma'am, at this time, would you like to make the time that you all have will include any opening and closing statements should you choose to make one. You're not necessarily required to do that, as well as any examination. Ma'am, are you ready to proceed at this time?
Yeah.
Or would you like to give an opening statement?
Is this where I question or just an opening statement?
An opening statement, you can choose to waive it.
Okay.
Would you like to make the opening statement?
Sure.
Okay. Attorney Parker, would you like to make an opening statement? Thank you. Ms. Minix, this is your opportunity to call yourself as a witness. You could call Mr. Padilla as a witness. It's your case in chief. So however you would like to proceed. If you don't want to call Mr. Padilla, you just wish to call yourself and let me know what you want me to know and prove up your allegations, you're more than welcome to do that. It's however you would like to proceed.
Okay. Thank you.
You're welcome. Just make sure you speak into the microphone. You speak a little low. I want to make sure I hear you.
Okay. Can you hear me?
Just pull it closer.
Yeah, it moves, so you can pull it closer.
To you.
There you go.
Can you hear me?
Yes.
Okay. Thank you.
Go ahead.
All right. So Judge Bailey, I was requesting these summary of relief funds because I've received 0 relief payments from the respondent, with the exception of 3 involuntary Office of Attorney General payments that they had to seek funds. So Mr. Padilla has not responded to any of the court orders or documents that have been requested. What I would like to ask of, can I ask Ms. Parker or Mr. Padilla directly on information?
You can call Mr. Padilla as a witness.
Okay. So in summary, so let me just back up. I apologize. So looking at the totals, just based on what I am seeking today, although I don't think you included the summary, in terms of court orders minus the attorney fees of what I'm seeking, we're over $100,000. And I have been paying for my children solo, paying for a school that I'm not court ordered to pay just to keep my child at school. I'm providing for them. Mr. Padilla is court ordered to appear. He has visitation and possession schedule in which he has not picked up the children since, I believe, August 25th of 2024. Therefore, I have the children 100% of the time. I'm incurring costs for the children 100% of the time. And therefore, I'm, gonna also ask for maybe an increase in child support since I'm having to pay and pick up, cover the boy's costs when Mr. Padilla is not coming to his court appointed appearances and visitation.
Okay, let me just stop you right there, Ms. Minnick. So this hearing is only about the enforcement. So the motion that you filed back on May 15th of 2024, that's all that I can consider today. That's the scope of the hearing. So any modification or anything of child support
Okay.
is going to be irrelevant to this hearing.
Okay.
Okay,
So
go ahead.
then, okay, so then I would like to call some questions for Ms. Parker on behalf of her client or directly to him.
Directly to him. So you're gonna call Mr. Padilla.
Okay, I'm gonna call Mr. Padilla.
Okay.
Mr. Padilla, could you state for the record your formal name for the courts?
I'm going to invoke my Fifth Amendment right.
Okay, Attorney Parker, have you had an opportunity to speak to your client about invoking his Fifth Amendment right?
Yes, Judge, briefly. I think it's his contention that he doesn't want to testify, given the contempt that's pending.
Okay. All right.
Is that, I don't know, is that overruled to state? I'm sorry, I don't understand.
Well, he has the right to invoke his Fifth Amendment right. And you're representing yourself, so I can't tell you what to do.
Okay. So, Mr. Padilla, would you state for the court record where you currently reside?
I'm invoking my Fifth Amendment right.
Mr. Padilla, would you please state for the record your last employment?
I'm invoking my Fifth Amendment right.
Mr. Padilla, since we've submitted this Exhibit 1, considering a primary care note, could you explain to the court who Miss Margaret Grinnell is?
I'm invoking my Fifth Amendment right.
Judge, I'm sorry, I'm confused. This was an approved exhibit submitted by Ms. Parker's.
And he has the right to invoke his Fifth Amendment. He has the right to invoke the Fifth Amendment. Mr. Padilla, if she asks you any questions, would all of your answers be that you're invoking your Fifth Amendment right today?
Yes, ma'am.
Okay. So he's not going to provide any testimony, and he has the right to do that.
Okay, and he has the right to do that on for the contempt hearing on the next one?
If he
If
does,
we're scheduled?
he does. He has the right to invoke his Fifth Amendment.
Okay, thank you,
Mhm.
Judge.
So you can call your next witness.
Yeah, well, I'm my next witness.
Okay, go ahead.
So, Judge Bailey, what I'm questioning here is this primary care note that's performed by a Margaret Grinnell that has no credentials. I don't know, it doesn't state that Margaret Grinnell is a DO, an MD. There's not a location at this. As far as we know, this could all be made up. And it's unauthenticated, and not valid. What I would like to state in here, since this was admitted to the courts and accepted by the courts, there's a claim here in this document that Mr. Padilla refers to somebody as his wife. To my knowledge.
Hold on one second, man. I don't want you to go down that rabbit hole of getting
Okay.
distracted.
Okay.
Do you have your motion for enforcement in front of you? The one that you filed back on May 15th of 2024?
No, I don't have that one.
Okay, here.
Yes.
You can have this copy. I'll just look at it from the computer. So this is what you filed with the court to bring this motion. To bring about this hearing. So what you filed is what I need to know in order to consider
Okay.
your relief today.
So, okay, so Judge, what I would say is that the Office of Attorney General and myself, we are aware that Mr. Padilla has had employment at multiple locations since looking back, Judge, from your from October of 28 of 2024. Mr. Padilla had admitted in court that he did have a job, told you he lost his job, and he lost his job due to sales performance. If you go back to look at the court recording. Since then, Mr. Padilla has had multiple jobs in which we were able to obtain child support. Additionally, Mr. Padilla represents himself and says he's self-employed, has these businesses, is an angel investor, a CEO and a founder, a vice president, has global titles, executive
Objection is
titles.
Speculation and no foundation, hearsay potentially.
Sustain as
Where
to,
she's getting this information.
sustain as to speculation.
That information came from direct, so these were direct payments from the Office of Attorney General and voluntary payments, but also these are directly from Mr. Padilla's LinkedIn profile in which he's the owner, editor, and creator of.
Objection to LinkedIn is hearsay.
Sustain.
So Mr. Padilla has listed these multiple high-level titles with employment and is obtaining
You're an objection of, again, it's hearsay.
Sustain.
he's obtaining employment and.
Like I said, if you refer to your motion, it'll keep you on track.
Okay, sorry,
No, it's okay. Whatever you
So-
filed in there, that's what I would need to know that you're trying to seek relief for here.
Yeah, I'm
today.
trying to seek relief for, child support for the tuition costs in which I've had to incur for the 50% of the extracurricular activities that Mr. Padilla is court ordered to pay, as well as the 50% of unreimbursed medical and dental support. Let's see. And any future violations as well as attorney fees. Judge, this is all on, you're right, in page 1 through 5.
Okay, so you just have to prove up each one of those allegations.
Okay, so that from the proof is my exhibit on the extracurricular activities. That's a W6, that document. And that was just a summary to make it simple and easy for you, Judge, and the courts and everyone to see that he is owing to date $10,000, $224.92.
This is referencing W6.
W6, but that's all been uploaded by court orders and through our family wizard. So every one of these totals that I'm referring to has date and time stamped receipts that have been communicated, uploaded to Mr. Padilla through our family wizard, which is court ordered.
Okay,
Okay? And that brings me to the W7, and that's just showing the documents because I pulled the direct report off of our family wizard. So these are 1 through 40 showing all the expenses, these extracurricular activities, if that makes sense.
yes, I can.
Since I did not, and I had proposed this question to Judge Lee, I did not bring submit the actual receipts, but I made copies for the courts today because I didn't want anyone to come in and claim they've never seen a copy of
Okay.
any receipt. So I have everything from school tuition, extracurricular, unreimbursed medical and dental expenses, all in my possession in multiple copies to submit to the court. Okay, moving forward, the expenses on reimbursement is the W8 since I believe that W8 was accepted, correct? I just don't want to speak out of turn. Okay. Is just talking about, exchanging, asking through our family wizard when you were planning to reimburse me. Was there going to be a reimbursement? And these are all time stamped, again, date, time stamped, and also shown of when the respondent reviewed or viewed the messages. Okay, that's what our family wizard platform's designed. W9 is and let me just make sure I'm not skipping anything, Judge. Okay, So going back to my son's school tuition, since I'm looking at exhibit W1, I have been out of pocket $62,000, $327.83 for my son Urban's Shelton school tuition. Okay, and with that being said, I provided supporting documents showing that I've made those payments to the school, and that's through the exhibit W15, our family with school tuition expenses. And also W10 was accepted, and those are emails just asking, you know, did he receive? We're on e-post. Shelton School send out multiple emails directly to parents, but also they send an e-post when school tuition, uniforms, pickup times, you know, and when you can file for tuition assistance, Judge. And in these documents in W10, there's a lot of communication around, you know, there's tuition assistance. If Mr. Padilla is claiming he's unemployed to you and losing employment, then why aren't we applying for tuition assistance for our son to continue at that school? When talking to the school, they said they have communicated directly to Mr. Padilla on past owed balances. They have communicated the enrollment.
Hearsay.
Sustain.
They have communicated with him on what he owes. They have communicated with him
Objection.
on
Hearsay.
tuition assistance.
Sustain. You can't tell me what anybody else has communicated.
Okay. Okay, well, it's all, okay, so we do all receive those emails as parents from the school. They do not omit a parent, such as Mr. Padilla, or notifying him when enrollment contracts, tuitions due, financial assistance, when you can apply for financial assistance and deadlines, okay? So that's all been very well communicated. I even explained in these exhibits that they were due. I send in what is required. If you look at all the communications in exhibit 10, Judge, I'm actually laying it out in terms of what's expected for tuition assistance. So he could have applied for our son for tuition assistance.
What's the outstanding amount that you're asking for in healthcare? I have extracurricular activities and I have
Yeah,
tuition.
good. Okay, and healthcare, thank you. As of right now, just because this is unreimbursed, what my insurance has not covered for the children is his 50% is owed as $4,388.30, Judge. And
Thank
those
you.
are all well provided with, again, receipt. I have physical receipts here. We're court ordered to use our family wizard, which I would love to continue to utilize. And Mr. Padilla has those at his discretion. I don't know if the courts allow, but he could pull up our family wizard and pull these up himself with the hyperlinks, with actual date and time stamped receipts. Okay. And then lastly, Judge, what I was asking because of, you know, again, I was asking for some relief for some of the attorney fees. Of course, you know, I don't have an attorney as of right now. But a lot of these fees of not appearing in court on the first time, if you go back to records, Judge, I apologize, I called you Judge Lee, because we've been on multiple communications with Judge Lee, Judge Bailey, Judge Bailey, because he had not appeared for court. So then we had to get pushed. And so there's been several times that we were postponed. And I did ask for one continuance myself and filed for a motion because I had terminated my former legal team and I was also needed to collect myself as well as get prepared. And actually, Judge Lee, I was in hopes that Mr. Padilla was gonna continue to be gainfully employed, in which he was multiple times at multiple corporations. It seems as if Mr. Padilla lost employment every time the Office of Attorney General had caught up with him. And I don't want to say caught up, verified his employment. and and started collecting wages, garnishing wages. And then Mr. Padilla all of a sudden would always lose a job. Or maybe what he would claim as terminated as job. I'm not exactly sure. So I was asking for the amount of relief, and that wasn't including today, $37,543.50. And that's just pertinent to the hearing cost only, Judge. That is not the whole case. Because I've paid a lot more in attorney and legal fees than that.
Does that 37,000 amount include attorney's fees?
That was yes, that was attorney fees from all the hearings from, as you recall, back in, all the way up until the last hearing.
In
I had
June?
attorneys.
What is that amount without the attorney's fees?
The total of what Mr. Padilla what I'm asking?
Yes,
Without
for
attorney
the
fees?
extracurricular activities,
Okay,
the
yes,
tuition and the
Yes.
healthcare.
okay, pardon me 1 second, I'm sorry. Including child support? Or
Well, you didn't ask for
okay,
child
okay,
support in
not
that
this one.
motion.
Okay, 76,941.
Wait a minute, that's higher. I'm saying without the attorney's fees.
Yeah, these are not including the attorney's fees, so.
So
I'm talking about school tuition, unreimbursed healthcare, extracurricular activities, not attorney fees and not child support. That total comes to $76,941.05.
Okay, so the first number you gave was $37,543.50.
That was the attorney fees, because, I'm sorry, that was the attorney fees. You were asking me to omit that from the.
Okay,
So I
okay.
admitted, I omitted that to my calculation, going back to just the school tuition, the extracurricular activities, unreimbursed medical and dental.
Okay,
Okay, that's the total. As of today, and that's changed even from the time this filing.
all
And
right.
will continue to change as I have to keep my child at this school. If Mr. Padilla does not file for tuition assistance, and if Mr. Padilla does not pay his school tuition.
Okay, so you ran out of time, Attorney Parker,
Yes, Judge, I'd like to ask her a few questions.
go ahead.
Okay, Ms. Minix, this motion to enforce was filed on May 15th, 2024, correct?
I believe so, of the one in front of me? Correct.
Yes, okay. And you guys were in court before that time, correct?
We
You
were
had several court hearings before May of 2024, yes?
I believe so.
Okay, so in your 37,000, you're asking for attorney's fees. The motion to enforce was brought at some point after you guys have been in court, correct? You were in court prior to May 2024 with whatever matters y'all were dealing with, correct?
Correct, but we also were supposed to be in court for a hearing that was postponed. So we were ordered to hearing, Judge Bailey, if I recall, if you can pull up the records, we were scheduled to be in court in which he did not appear.
Okay, so the time of the enforcement on attorney's fees, the enforcement's May 2024. And then there were some hearings in the remainder of 2024 for the enforcement, correct?
Yes,
Okay, there was a January hearing of 2025, correct?
correct.
You asked to postpone that hearing till June, correct?
That January 5th hearing was on the temporary orders.
It was on the motion to enforce.
Okay, the
You
motion.
asked to postpone that till June, correct?
The January one,
You said you didn't have counsel, you wanted to move it to June?
I believe that, if I recall, I believe so.
Okay. And
There
then
was one prior to that we were to appear previous to that your client did not appear, or maybe he did appear.
Okay, yeah, I said in 2024, there may have been some dates.
Yeah, there's some
From May to
multiple
the
dates.
end of
It's confusing.
2024. Not at the same time.
Thank you.
From May 2024 till the remainder of 2024, there may have been a court date or two on the enforcement, correct?
Correct.
Okay, but January 2025, there was a date. You asked to postpone that to June, correct?
Well, I asked to propose, to the summer, and then they came back and proposed dates, and then you said you were available, and then I said, I'll make myself available.
Okay, and then in June, the court pushed us to this date, correct?
Correct.
No one appeared in June, like there wasn't a coming to court, coming down here downtown, any of that stuff.
Correct. And I didn't have legal counsel at that time.
Okay, all right. So again, for 6 months, you're asking for 37,000 in attorneys. Okay.
That,
All right, and you guys got an order in this case. There've been several temp orders, but the order attached to your motion was entered by the court on January 2nd, 2024. Is that correct?
what page are you on of
It's
the
page
exhibit
15.
W2?
Motion to enforce what judge handed you. I don't know if you have that there with you. I don't think you're
Are you
looking at the
talking-
right thing.
Oh, okay. This is
So that's January 2nd, 2024, correct?
correct.
Okay, what months does your son go to school? The one who was, you said Mr. Padilla was ordered to pay tuition for?
So they typically start school in August, and every year it varies,
Okay, and then it goes through when?
till May,
Till May?
typically through up until Memorial.
Okay,
And then they go to summer camps and summer schools.
is summer school continuous?
Um,
Just activities? No, I'm saying, is he in school in the summer? No.
no, he goes back, both go back to a prep camp that preps them to go back to the next grade.
No. Okay, so. And the January 2nd, 2024 order on the motion to enforce ordered Mr. Padilla to pay tuition, or is it Urban's tuition? That's the
Okay.
tuition you're mentioning, correct? That you want reimbursement for?
Yes, Urban's tuition.
Okay, how much is that a month?
It varies, but right now it's currently around just shy of 3,500.
Okay, was it about that last year? Last January?
I'd have to look, I mean, look,
So about 34, 35. You said shy of 35, that's fine. Okay,
well, I had to pay in order to enroll him because Mr. Padilla was in arrears. So I had to make some big payments from what he owed from past, which is in some of my exhibits, in order to continue to enroll my son, because the school would not accept my son if we did not get current on financial standing.
okay, but he is court ordered to pay this on January 2024, January
Actually-
2nd, 2024, correct? January 2nd, 2024.
Well, okay,
Okay,
and if you're looking at the exhibit W2, right?
I'm looking at the order.
Okay, the order on page 1, and what it states was in accordance with Rule 1, right? It's adding modifications from what was initially filed with the courts, Rule 11 agreement for temporary orders.
And that agreement
then-
was from December 2023, correct?
1 year. October 24th, 2023 is when your client signed this.
Okay, so just to go through for the court, there was an order signed October 24th, 2023. And you're saying that one called for him to pay tuition, correct? We'll say that it did, okay? And then on December 5th, 2023 is another Rule 11 agreement that also said he pays tuition, correct?
Should.
Okay, and then we have the order signed by Judge Tenike on January 2nd, 2024, the temporary orders that ordered him to pay tuition.
On what date did you say tonight?
January 2nd, 2024, the order that's attached to your motion.
You're saying January, I see that.
No, it's the one judge gave you. We've already discussed
Okay.
those. The one judge gave you.
Okay,
So that's the time he's ordered to pay tuition. All right, then in July 10th of 2024, isn't it true there was another temporary order? And that ordered him to pay child support, is that correct?
that's when yes, was the first time we entered and asked for child support
Okay,
because we set an amount. In previous, we had mentioned it and said we would determine an amount at a later time.
the previous orders in fact state specifically he's not ordered to pay child support, correct?
Before that July date,
Mm-hmm,
correct.
okay,
Before that July date of 2024, but the
okay.
judge signed those orders stating child support as of,
It's July 10th, 2024 is your child support order.
okay. But there's mention okay.
Now,
Just in-
in that order, he's also ordered to pay 50% of extracurriculars, correct?
He was ordered to pay that prior to those orders, Ms. Parker.
But he's ordered it in this order, correct?
In that one too. Yeah,
Okay.
correct.
But he is not in this order ordered to pay tuition.
It's a build.
Your Honor, I direct the court to the 24 cause number. And that's default further temporary orders, July 9th, 2024.
Okay,
There is no order for child support there, Judge. I mean, for tuition reimbursement
Wait,
or coverage.
okay. The court takes judicial notice
Thank you,
of
Judge.
all the contents of the court's file.
And then, ma'am, when did you and Mr. Padilla separate?
you mean when did Mr. Padilla was ordered out of my house and he agreed? In October of, I think it was October 23rd or 24th of 2023. But
You married?
no, ma'am.
Was there a divorce action filed in these two cases?
Mr. Padilla filed an order and hired a former attorney who I think withdrew from him. You'd have to look at that, who I believe was a former Dallas County judge.
Okay,
Mr.
he filed
Lopez.
for divorce. Okay. Has that been resolved?
Miss Judge Bailey. Judge Bailey did sign a motion for summary judgment, explain that to Mr. Padilla at that court hearing on October 28th of 2024, was it?
Was there a divorce granted?
She's already signed the motion. I have that.
Okay, I withdraw. the
Judge
question.
Bailey,
No, it was
October
the
20.
order she's referring to is the October 23rd, 2024. I granted the partial summary judgment finding that there was no marriage.
Okay, so the last time living together was in the year of 2023, correct?
That he resided in my home
Okay, all right.
on a different floor in a different bedroom.
Just wait on the next question.
Okay.
Your Honor, may I approach the witness?
Yes.
I'm showing you the July 9th, 2024 default further temporary orders.
Can you? What exhibit?
It's probably in your W-2 somewhere, or the one you had all the orders. But on
Where?
page 2 there,
It was multiple because they were a build.
well,
Is
we
this
can
one?
look at this. Yes, okay. So this is can you go back to page 2?
Okay, just.
That's the July 9th, 2024. And this section at the top of the page 2, it says that you are as parent temporary joint managing conservator should have the following rights, correct? It lists out your rights, correct?
Correct.
Okay, and at the bottom of that section, read that part there. It is ordered.
It is ordered that all other rights and duties set forth in the agreed temporary order signed by this court on January shall remain in full force and effect.
Okay. So all other duties,
The-
rights and duties agreed in there, and this is under the section which is talking about your parental rights, correct?
It looks like my former legal team wrote that way.
Okay, when we go down to possession and access, it starts to speak about this time forward, correct? August 2nd, 2024.
Correct.
It gives out a possession order for him?
Correct.
Okay.
Continuing on page 3.
Isn't it true that nowhere else in this order does it say that the orders of prior are continued besides that section about your rights?
In this order, I think that is an understood. I don't think that was to be, and at the time, Judge Bailey and Ms. Parker, if you could see in these orders that a junior attorney was working on the orders and I think made a couple mistakes and admitted to me that he made like just a couple mistakes in the orders, like on
May I
that.
approach, Your Honor?
Yes.
Okay, I'm showing you the order, agreed temporary orders attached to your motion. The last page, right above the date sign and the judge's signature, what does that statement read?
These agreed temporary orders shall continue in force until the signing of the final order or until further ordered of this court.
So this was January 2024, and in July 2024, you got further orders, correct?
Additional as a bill, further orders to the current standing court orders.
Okay, so the last order of this court does not contain a provision for tuition reimbursement, correct?
Not to my knowledge.
Okay, it does, different from the other orders, it does put Mr. Padilla on child support, correct?
In addition, that's in July. Are you talking
The
about?
July, yes,
They-
that's the last order.
That's when we billed. But in that, if you want to look at page 5, since you are looking at these orders, it does have. school enrollment.
Sustain. The order that I'm looking at, that's dated July 10th, 2024. There is no reference of Mr. Padilla paying tuition. It's only him paying child support.
So,
That's our interpretation, Your Honor, correct?
sorry, Judge, since she quoted January 2nd with Judge tonight, on page 5, it does talk about school.
No. She moved away from that one. So after January, you had an order that came out in July. So that January order had Mr. Padilla responsible for some tuition payments, right? After that, in July, the tuition payments stopped. And then he was ordered to be placed on child support because he can't do both. He can't pay tuition and be on child support. So that's the reason why the tuition, the most current order, the one in July, that one does not have him doing any tuition reimbursement. It's only child support.
Well, that's very underestimated then. I see what you're saying by legal term. I see what you're saying. Clearly, I don't know if that was a oversight by.
Well, that's the order, and I can only go by what the order says. Attorney Parker, do you have any other questions?
Yes, Judge, just a couple. Ms. Minix, did Mr. Padilla pay you child support in August of 2024? It seems that it's your testimony, he has not paid any child support, is that
No,
correct?
what I stated was there were 3 involuntary child support payments that the Office of Attorney General.
Okay.
The state went after and garnished his wages, and they informed me they were involuntary.
Okay, so.
So I've only received 3.
Hold on, one at a time.
It's your testimony, he has not voluntarily paid any child support since that July order, is that correct?
Outside of 3 payments that we received. That's
Okay.
Or I received.
So from July until today, October 27th, 2025, he has made no child support payments, correct?
There were 3.
Voluntarily.
No, I have
Okay.
not received any check, nothing in the mail, nothing in my bank accounts,
Okay.
besides 3 deposits that came from the state through our, the Office of Attorney General, and those are denoted and also an exhibit.
Okay, that's enough. Attorney Parker, that was your last question. Attorney Parker, did you do any calculation between the orders?
Yes, Judge.
Okay.
The, Judge, that would be January. through May, Ms. Minix testified school was out by Memorial Day.
Are you specifically talking about tuition?
Yes, ma'am.
Okay,
On tuition, Judge. That's what I'm speaking of.
all right.
So from that order date, if we set it at, she said it's shy of 35, if we say 35, that's gonna be January, February, March, April, May. Judge, that is $17,500 on tuition.
Okay.
Judge, are we completely out of time?
Yes. On the extracurricular,
Judge, I don't have that tabulated. I do know that mom put some school uniform costs into that, and that was supposed to be extracurricular uniforms. I don't think it's let me see.
Judge, the language.
according to the language of the order, it is ordered that extracurricular expenses shall be split as follows: 50% by Doyletta Lynn Minix and 50% by Renato Padilla Jr. These expenses include but not limited to the cost of uniforms, travel fees, camps, after-school programs, and sports.
Yes, Your Honor. And since it's speaking of extracurriculars, we would say that's an extracurricular uniform, not school uniform materials.
Right. It reads clear. It starts with extracurricular.
Okay, so in our family wizard, you can only put, like, there was a school tuition and then there's extracurricular.
Okay.
So, if I categorized it incorrectly, did you want me to put it under school tuition?
It's not tuition.
Well, it's your motion. So if you want me to grant something,
So if it was
if it's not correct for me to consider admitting the exhibits, I can't give you that relief.
so you're stating that because I identified, and can you explain exactly which line you're speaking of?
There's several parts of extracurricular where you list, I'm not sure if this is the correct sheet or not. I'm looking at one. It's like number 7, uniform school shoes, It'll say that it's a school uniform, not an extracurricular. But we just say that that's not proper under the order. Those fees should not be there.
So those should have
She can
been
strike
categorized as school.
They're not tuition, nor are they extracurricular uniforms. They need to be struck.
So she can work on that.
Yes, Judge.
Healthcare, she has $4,388.30. From reading of the order, that seems pretty accurate because nothing changed with any language in the order related to healthcare.
It didn't, Judge, but in that original order, if you'll look at page 10 of the agreed temporary orders of January 2nd, 2024.
Yes.
Under section 7, where it states her name, it says that they will split 50-50 if at the time the expenses are incurred, she's providing health insurance and he is paying additional child support for the cost of health insurance as ordered. That was never ordered. There was no child support ordered. He was not ordered to pay health
That's true.
insurance. So sort of judged by the way that term is, that kicks out the 50-50.
Yeah, it does. I know you're hired for the enforcement, right? Never mind. Because the order language, the way that this order is written, it doesn't really make it enforceable. It's loose. You see what I'm talking about? The agreed
On
temporary
page
orders
10.
on page 10, yeah.
So just that last comment there, toward the end is paying additional child support for the cost of health insurance is ordered.
Yeah, he wasn't ordered to pay child support. I mean, that didn't come until later in July.
It was gonna be determined, right?
So,
But it wasn't.
I can't-
at the time.
I can't find that he violated the healthcare portion.
I can thank my former legal team for that.
That's what you said.
Judge Bailey, you're laughing.
So yeah, as far as as far as the order, excuse me, the motion for enforcement that you presented, with clearing up the discrepancy between the language, the only thing that the court can do is confirm arrearages on the amount of tuition that wasn't paid, which would be approximately $17,500. The extracurricular expenses, the court can't confirm that right in this moment without you making the deductions from the school uniforms that you included in that.
So I just have to correct that.
So if you,
Next one?
yeah, you and Attorney Parker, you all get together and correct that. And you all can go out in the conference room. So then I can move to this next case here. And you all can clear that part of it up and then just step back in and let me know what that amount will be.
Thank you.
Yes, ma'am.
You're welcome. Thank you all.
Thank you, Judge.
You're welcome. All right.
Rivera.
Which case are you here on? Okay, thank you. All right. And I see Mr. Walters on Zoom. Are you represented by an attorney, ma'am? Okay, Mr. Walters, are you represented by an attorney?
No, ma'am.
Okay. All right. So next I have Owens, DL 2014623.
Yes, ma'am.
All right. And Attorney Franklin, you are on this one, right?
Yes, Judge. We received notice up here on this one.
Okay. Yes, I have a motion for enforcement that was filed back in June. For child support. All right. Attorney, Irmis, this is your client. Your client is the moving, right?
It is, Your Honor.
Right. Have you and the other side had an opportunity to discuss this case?
We have not had any direct negotiations. There have been no child support payments that have been paid since the filing. But if the court could put us in a conference room, I can ask him if he intends to start paying.
Yes, I think just reviewing the motion, I think that'll be a good idea.
Mhm.
Okay, Attorney Franklin, you want to go in there too?
I can, Judge, yes.
Okay. Right, let me.
And Judge, would you like Catherine to go in as well, the movement?
I guess that'll be a judgment call on, I'm not sure if.
I don't want to make any, I can't make any agreements without her, so I think it would be helpful and efficient if she could join, Judge.
Okay. All right.
I'm going to accept the invitation and I'll see you in a few.
Okay, sounds good. And Miss Owens, I sent you an invitation over there as well as Mr. Owens. All right, Richardson. Attorney Pinkerton. Oh, it's on mute.
Okay, I can go get Kim. She's inside the courtroom.
Okay,
Can you hear me?
yes. Oh, she's here?
Because we're here as well, Judge. We're just out in the conference room.
I can't hear anything.
I saw you. Can you hear me, ma'am?
I can hear you. I
Hold on
don't
a
think
second.
that she can hear you, but I think the Attorney Pinkerton is not in the courtroom.
Oh, okay. She must be. I see where she is. She's outside of there. Attorney Sullivan, have you had an opportunity to speak with Attorney Pinkerton?
Yeah, and not today. In the past, we've spoken. Um, uh, if you want to give us 2 minutes, we could do it again, I guess.
Yeah, Stitch's got one.
Find each other? Can you hear me?
I can.
Okay, you both are here. Can you find each other out in the hallway?
Oh, yes, Judge. Sure thing.
Okay, yeah, you all do that. And then I'll check back in. Okay, Walters. Ma'am, you can come up. Sir, would you turn on your camera?
Yes, ma'am.
Oh, you can come up here. You can come up here.
Well, that wasn't what we hoped for. Respect to the same.
So, all right. So you all are here today on an enforcement that was filed. Hold on, it's a modification that was filed too. Okay, the enforcement was filed July 14th, 2025. Is that correct?
Yes, ma'am.
Okay. Let me look at your. And you're referencing a temporary order that was put in place.
Yes, ma'am.
Okay, let me find that 626. Here we go. Okay, Mr. Walters,
Yes, ma'am.
looking at your motion, and I see where you attach the order, but I
Yes.
see where the specific violations.
Pretty much she took them from me on the 8th. On the 6th of June. I didn't see them until September after school started. And she had daily visitations with them from 6 p.m. to 8 p.m. And then I texted her and asked her for the kids. She wouldn't bring them to me. She ignored most of my text messages, if not all of them.
Okay. I'm looking at you all's court order. So on a motion for enforcement is very specific, okay? So in order for me to hold someone in contempt, which is what you're asking me to do, the violations have to track the language of the underlying order. So let me tell you what I mean by that. Do you have the temporary order in front of you?
Yes, ma'am.
All right, so go to page 6.
Okay.
Possession order. You see that?
Yes.
Okay, so who is Kaylin Quinenthia Stewart? You. Okay, so this is your possession schedule. I'm looking for your possession schedule, Mr. Walters.
I mean,
So what it's saying is that the possession schedule that's outlined here, this is for mom's time, and any other time outside of this is yours.
yes.
Are you alleging that she didn't give the child back outside of this time?
Yes.
Okay, so your motion has to say that. So you have to go one by one and lay out each one of the violations for me in order to hold her in contempt, or even to find that she violated parts of the order. Does that make sense?
Yes.
Because without it, not only do I not know the violation, but more importantly, she has to be on notice of her due process rights. She has a right to receive notice of allegations being brought against her. And without that, she can't properly defend herself in court. So you the motion has to be specific with the violations. I don't know your financial situation or whatnot. You don't have to tell it to me. But with motions for enforcement, they are so specific that it may not be a bad idea to consult an attorney. And either one of you can, if you want to file motions for enforcement. It may not be a bad idea to consult an attorney because they are so specific and technical that if they're not done properly as outlined in the Texas Family Code, my hands are pretty much tied.
Okay.
Does that make sense?
Yes, it does.
Okay, so while both of you are here, I just want to encourage you to follow your court order. Whatever it says, even if it doesn't seem like it makes sense or it's enforceable, follow it as the best you can. And there are ways that you can bring a motion before me for me to clarify it. Does that make sense?
Yes.
And from reading your order, just off looking at it, it needs some work. Because as it's written, it's not really enforceable to neither one of you. And if you don't fix it, you'll be right back in here in front of me. Not only will you file a motion for enforcement, she could file one too. Do you understand? You both understand what I'm saying?
Yes, ma'am.
Okay. So as best you can, just follow the court order as it's written until it is modified, okay? Does anybody have any questions for me before you all leave?
No, ma'am.
Okay. Well, thank you all. You're
Thank
welcome.
you.
Yes. You too. Hold on 1 second. The court is to do a work.
I mentioned that.
I mean, you. Okay.
Well, also.
Oh, you get to be a witness.
You guys will stand, right? You can stand up here and everyone else is more than welcome to come and take pictures. ¿Usted se quiere sentarse? Would you like to sit? Would you like to sit? Or no? ¿Te quieres sentarse acá? ¿Te quieres para estar más cerca? Okay, and everyone else can come forward.
That's my brother.
¿Alguien va a tomar video? ¿Alguien puede tomar video aquí? Está bien. Okay. They're gonna be ready. They're going to get ready. Oh, I said, you okay?
Yeah.
You want to take me charge? Yes, sir. Let's see if we can. I'm there. Okay. Picture, video, whatever. Go.
You can come stand right here in the front. You get a good shot with the seal behind me.
Yeah, thank you. We really appreciate this. After like the 20th phone call, man, we were like, oh man, it's not gonna happen.
Oh, yeah. You ready? So you'll stand right here and you're gonna face her and she's going to face you. Okay. Make sure y'all ready?
Yes, ma'am.
All right. Nosotros estamos reunidos aquí para celebrar el matrimonio de David Michael Short y Carolina Maria Corona. Es su acuerdo para proceder hoy. Are you ready to proceed with your ceremony? Okay. El matrimonio es sagrado, es un pacto bajo Dios y debe ser llevado a cabo sobria y honestamente. David, Do you take Carolina to be your lawful wife, to love, honor, cherish her, be honest with her through sickness and in health until death? Okay. Carolina, usted como hace David, su conyugue, legítimamente casado, ámalo y hasta que la muerte los separe. Okay. ¿Tienes dos niños? Repeat it después de mí. Repeat after me. With this ring, I be wed. Okay. Con este anillo, mi caso. Repite después de mí. Con este anillo, me caso. Por el poder si mi cito otorgado y debajo la autoridad del Estado de Texas, declaro marido y mujer, besos, by the power vested in me and under the authority of the state of Texas, I now pronounce you husband and wife. You may kiss your bride. Felicidades. Congratulations. Let me see. It's a very picture with mom.
Dave, yeah,
Yeah.
that's a video. I'll go.
Very good. Yeah. Of course, you're welcome. We'll have to do a group photo. Oh, yeah, of course. You're welcome. Here, let me clean out the camera. One, two, three. One more. Stay right there. One, two, three. Okay.
This is the best part here.
It's always the best part of my name. This is an adoption. Yes.
Made 36 phone calls before.
Really?
Everybody was saying, yeah. No judges, no. Instead, you judges better than once a year. So, no.
Well, I'm glad I could do that for you.
Me too.
Yeah, yeah, that's a lot. You really wanted it. Yes. Probably on TikTok. Okay. I need to
You
look
have
back
that.
here. Social media. Y'all ready to take group pictures? Yeah. Oh yeah, come on, let's do it. On a selfie. You. Then we have to let us. On my phone too.
This is actually my vest and tie from my wedding 10 years ago.
Oh, that's so nice.
His sister is my wife.
Oh, how cool is that? Okay.
Everybody gets.
Everybody.
Just send it to them.
Here on now, there's something.
You post everybody. Thank you.
This.
Yes.
All right. Now.
Congratulations, you're very welcome. Nice to meet you.
I have to have my due. This is the gentleman above.
Yeah. You picture on there.
All right, okay, you want one second?
Sure. Shoes. Sure.
Oh, yes, maybe he's sleeping through those photos.
We got here about 9 a.m. and he has barely made a pee.
Oh, that's good. What a good baby. 2 months? No. Oh, yeah, yeah.
That's like his face, I think.
Would you like for us to take this back, or we walk them back on Fridays, or you can walk it back today?
When do I pick it up?
They'll mail it to this address.
So look, come to our house then, or?
Whatever we have on.
What did you think? I'm just. Parker.
Absolutely, I got you covered. Y'all have a good rest of the day. You're welcome.
It's so good to see that you speak Spanish.
Oh, that's your day.
Oh. Oh, look at him, he's got the eyes open for the picture this time.
If you want me to go to here.
Musical phone. All right.
Yeah. You're pretty.
30-something courts.
36.
Yeah, Monday's hard. You tried to have this happen, huh? Monday's really hard.
Okay.
Yeah.
I say, let's do it tomorrow instead.
Did you all have a number?
Yes, Judge.
Okay. You all can come to the bench. You can leave that there. Yeah. Trust me, nobody's gonna take it.
Thank you.
You're very welcome. You all have a good day.
Yeah.
Oh, I think we wrote down.
This beats going to work on a Monday.
Yeah, it does. Bye-bye. Okay, think of buen dia.
Thank you, sir. You bet, absolutely. Have a good one. Y'all have a good one.
Extracurricular.
9,800.
Okay, let's go back on the record. Yes, so the court previously confirmed arrears for tuition in the amount of $17,500. And that's going to be I just did it as of yesterday's date, October 26, 2025, and the amount of extracurriculars, moving and opposing counsel went out and spoke about that, cleared up some things. And what is that amount, counsel?
It's $9,800.
All right. So I'm also confirming $9,800 in extracurricular expenses against respondent. Here you go. I don't know if he's still there. It appears as though respondent has logged off. So the court, it just became aware. It just came to the court's attention, but that is the ruling of the court, the confirmation of arrearages and extracurricular activities as of October 26th of 2025. Is there anything else for the record?
Take it that all of the monetary relief not granted is denied?
Yes.
Okay.
Yes, ma'am. You have any questions?
Current orders just be modified and charge, so I can get a population assistance for her. Because right now the school will let me and said, you could just ask the judge on Monday. If he's not, and he's not gonna apply, then why is he applying?
Mm-hmm. So
And put it in my name moving forward, and I can apply, so I can get some financial relief.
you all don't, is there a modification pending already? Did you already file one? I thought I thought
A lot of things going on in this.
yeah, and that's the thing, it's not only a modification, as you said, so you're able to apply for relief, but there needs to be some finality as well, because they're still temporal. Correct.
Mistake on possession. A couple things that scrutinized and harassing about from the language and.
Okay, so I don't see a modification pending. So if you would like to change anything with the underlying order, you would have to file a modification. Yes, ma'am.
So I'm talking about the school.
Yes.
Urban school. We'll open up.
You may have time. You may have time. Yes, because November, I mean, even although November is this week.
To keep this kid learning differences at the learning school.
I got you. Yeah, I say go ahead and file whatever you're gonna file in terms of modification of the temporary order.
I do need to clean up a little bit of.
And-
We've already signed the motion for summary judgment, so I was explained by my legal team that we're really back down to a custody case.
That's it, correct. That's it.
they said they were trying to save you money, refile, and they said they didn't want to be
more expensive. Yeah. Yeah. So I would just recommend doing that. Whatever you need for the underlying order, I would, even if you don't want to hire an attorney, I would recommend that you speak to one, just so you don't draw this out a lot longer. Yeah, because you don't want to confuse yourself either, because you're doing this on your own. And the more you do and it doesn't go anywhere, it'll confuse you. So yeah. Sure, go ahead.
Bring it back up. And then lastly, if somebody's claiming you've already signed an order that stated we're not married, he never. If somebody's claiming online or publicly or to institutions that we're married, what is the penalty for that? I looked it up, but I don't want to say, I'm asking you as a family.
And I can't give legal advice, and anything that I would say related to that will be considered legal advice. Only thing I can tell you is to consult with an attorney who would be able to answer that question.
They're right. That is not the case, been ordered, and we've determined that. What are the, as a judge, what type of
And again, my response would elicit legal advice. So you would have to ask an attorney about that.
That's why I'm asking, because there's some severe penalties and fines that, so I wanted to make sure when I research lay person who's in medical, I don't speak legal language, you know?
Yeah.
So that's why I'm asking. Because
Yeah, definitely speak to an attorney about that. Okay. Thank you all. If you would just give me an order.
Yes, Judge, I will.
Yeah, she's going to get an order. I want her to draft it because, as you just said, you don't understand the legal part of this. So I'm going to have Attorney Parker draft it. She's going to circulate it and get it to you. And then after you, on the confirmation, yes. Yes, ma'am. And then I will sign off on it and you both will get a copy. Okay.
Do I need to take any?
That you would have to speak to an attorney about as well. Yes, ma'am. It's okay. Have a good day.
Thank you, Judge.
You're welcome. No, you're okay. All right. On Owens, Attorney Franklin, Attorney Aramis, what we got?
Judge's position is he shouldn't have to pay support, so I couldn't do a whole lot with that.
Okay. All right. And then Attorney Pinkerton and Attorney Sullivan.
Yes, Your Honor.
Were you all able to have a conversation, come to an agreement?
I don't
No.
know where she is. I never could find her.
I just messaged you and told you I was available.
Okay.
All right.
We have conference rooms out there. You all can go to the court's conference rooms.
No, I'm in Waxahachie at the court.
You're at the Ellis County Court.
Yes.
Oh,
yes.
I had him looking for you in Dallas.
Oh no, I'm sorry.
Okay. So let me just put you all in the breakout room, okay?
Okay.
All right. Okay, are we ready to proceed on the Owens case?
I am, Your Honor. I assume he would need a rights hearing.
Yeah, okay, yes. All right. Mr.
Oh, I'm sorry, I cut you off.
Where did he go?
Is he maybe still sitting in the breakout room? I told him we'd be heading back out into the courtroom, but he may not understand how that works.
Okay, hold on. Okay, I see him.
And I think we'll get to come see you in person for this next setting, right, Judge?
Yes.
Excellent.
Okay, Mr. Owens, would you turn on your camera, please? All All right, both sides ready to proceed? Or all sides?
Your Honor.
All right. We're on the record in cause number DF 2014623. Counsel, will you please announce for the record?
On behalf of
Attorney Ermis, I think you froze. There you go.
Oh, no. Jeffrey Ermis on behalf of the movement.
Okay, thank you. State.
Alina Franklin with the Office of Attorney General.
All right. Mr. Owens, are you representing yourself here today?
Yes, ma'am.
Okay, would you please announce for the record? State your name.
Daynell Owen.
All right. Would you raise your right hand for me? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
All right. We are set here today, Mr. Owens, on a motion for enforcement or allegations of you violating the underlying court order, okay? So before I can actually proceed with a hearing on that matter, I have to have what's called a rights hearing to determine whether or not you're considered indigent. Because if you're considered indigent by law, I have to appoint you an attorney, okay? However, if you're not considered indigent, you still could proceed today in representing yourself, or if you are requesting an opportunity to hire an attorney, I can give you time to do that as well. Do you have any questions based on what I just said?
Oh, no, ma'am.
Okay. Attorney Ermis, you may proceed.
Your Honor, would you like me to elicit testimony regarding his current income?
Yes.
All right. Mr. Owen, how much do you pay for rent each month?
So my rent is about $1,100.
Okay. And do you actually give someone money for that, or do you have some sort of agreement regarding your rent?
I have an agreement. I do contract work, and the person that I work for also owns the home that I live in. When I get paid, the money automatically comes out of my checks.
Okay. So at least $1,100 each month comes right out of your check.
Correct.
Okay. And how much is your car note?
Well, it was $100 a week. I just had to get rid of the vehicle because it stopped working on me. As a matter of fact, they literally just picked it up just now.
Okay. So your testimony is currently you do not pay anything for a car note.
Not as of a few days ago, no. But I was paying something before.
Okay. And so this past month, I'm going to assume that the $1,100 was taken out of your check from your boss.
Correct.
And then how much for the month did you get in excess of that $1,100?
To be quite honest with you, sir, I'm not sure what it was. However, I will say this. I do know I made, as a matter of fact, you know what? Give me 1 second. I can give you a quick estimate. I'll go ahead and explain. So the type of work that I do is contract work for a company called CGL.
Your Honor.
Sustained. Mr. Owens, just answer the question that he's asking of you, okay?
Okay. Let me see. You said last month? What's the question?
That's where I started at. Yes, sir. I'm trying to help you figure out how much money you make.
I'm sorry. I'm looking at a calendar here. I have everything written down in front of me. I would say I made maybe about $1,800.
Okay. So when we add that $1,100 back in, that becomes $2,900, correct?
Right.
Okay. So $2,900 per month. Then you have no car note. Do you have any
Not
insurance?
anymore at the moment.
Okay. Do you have any insurance that you pay?
No, sir.
Okay. And how much do you spend on groceries each month?
It depends because I also help out with another child of mine that I had. For myself, maybe about $300. Maybe.
Okay. And for that other child, are you under a court order to make payments?
It is.
Okay. Are you making those court payments?
I pay mom directly. I don't go through child support, but I do give her money.
How much do you give her?
It just depends on how much she asks. But I
Yes,
was helping her out with my daughter's physical therapy, and that was about $300 a visit. Yeah.
Okay, so $300 a month there. Is that what you're saying?
Yeah.
Okay. What other bills do you have?
My phone bill, which is $130. And then because my vehicle was my work, I had to pay for gas on a weekly basis, which was maybe about $150 a week.
Did you say $150 a week?
Yes, ma'am.
Okay. Is that it?
That I can think of, yeah.
I pass witness, Your Honor.
Okay, Attorney Franklin?
No questions, Judge.
Okay. Attorney Aramis, is there anything else?
I'm sorry, Judge. I would ask one more question if I may.
Go ahead.
When was the last time that you made any court-ordered child support payment to any parent?
I'm not entirely sure, sir, as far as to answer the question directly. I'm not entirely sure. Like I said, I have helped her in between the time since then, but I guess you all would consider that as a gift and not a payment.
Do you think it's been more than a year?
Yeah. As a matter of fact, the last time that I gave her $500, she put it towards child support. It was in a favor that she needed to get her car out of the impound.
Was that Catherine or was that the other mother?
No, that was Catherine.
Okay. I'll pass the witness, Your Honor.
Okay. Is there anything else further from this witness?
Not from me, Your Honor.
Okay. Attorney Franklin, nothing?
Judge, no, the state doesn't have any questions for the witness.
Okay. So at this time, Mr. Owens, the court is going to find that you are not indigent. However, I will allow you time. I will reset this hearing to allow you time to find an attorney should you choose to want to hire an attorney. Would you today represent yourself, or would you like to have the opportunity to hire an attorney?
It would probably be smart, but I'm gonna be honest with you, man. In the current situations that I've been in here lately, I wouldn't be able to afford one.
Okay.
Your Honor, if I may, I do think a relatively short reset, because my client did ask about making a settlement offer to Mr. Owens, and I think 30 days to explore that, depending upon the court's calendar, would be appropriate instead of just asking for Mr. Owens to be put in jail today.
Okay. Yeah, I have the first available is December 1st.
Let me look at my calendar if I may.
Yes. Mr. Owens, are you available December 1st?
Yes, ma'am.
Okay. So I have the times that I have available left are 10:30 and 11 o'clock.
Can we get the 11 o'clock, Judge?
Sure. Mr. Owens, does the 11 o'clock work for you?
Yes, ma'am.
Okay. Does December 1st at 11 o'clock work for the state?
Yes, Judge.
Okay. All right. And this is an in-person hearing? Is that correct, Attorney Aramis?
Yes, ma'am. I'm so sorry.
No, it's
Yes,
okay. Okay, Mr. Owens, I'm ordering you to reappear here in person on Monday, December 1st, 2025 at 11 o'clock a.m. to my physical courtroom, which is located in the George Allen Courts Building at 600 Commerce Street on the 4th floor of the new wing, Dallas, Texas 75202. Your failure to appear could result in a KPS warrant being issued for your arrest. Do you have any questions about those instructions?
No, ma'am.
Okay. All right. Is there anything further for the record?
There's not, Your Honor. Thank you.
All
No,
right.
Your Honor, thank you.
And I won't see you before the Thanksgiving holiday. So happy Thanksgiving to you.
Happy
You too, Judge.
Thanksgiving to you as well.
Thank you. Have a good day.
May we be excused?
Yes, you may.
Appreciate you, Judge.
All right. Richardson.
Yes, Your Honor.
Okay. You all are back. 25. Eight. All right. All right. Who is Mr. Wilburn? Is that your client, Miss Attorney Sullivan?
My client's Mr. Richardson.
Okay. Mr.
I'm Mr. Wilburn. I just been waiting. I hit 11 o'clock, but no. This is me, Anthony Wilburn.
How you doing?
I'm doing fine. How are you doing today, Judge?
I'm great. I'm great. Which case are you here on?
The case number that I'm here on is DF 23-16538. I had filed a motion.
Okay, let me see where you're supposed to be. Okay, Don and Anthony Wilburn.
Yes, she sent me Brittany King said I was supposed to be in this court, and she gave me the Zoom. Yeah, the Zoom ID, and I put it in, and so I'm here. I just been waiting.
Okay, so it looks like your hearing this morning was reset.
Oh God, the other one was reset from the 2 weeks ago. It was reset, and they reset it to here today.
Yeah, what I see in my notes is no appearances were made at the October 21st status hearing.
No, I was on a call waiting. I waited for an hour on a call for that call, and then I called into the courts, and they said, "Well, that was reset to the 27th." I said, "No, I have a preliminary hearing that was for the 21st, and then I was supposed to go a week later and come today." And they said, "Well, no, the judge had reset everything to the 27th, so appear on the 27th," which I did. So I just done what they had told me. That they said it was reset on then because I had called in after and I got it. It's Zoom, so I got it. I took snapshots of it that I was on the call waiting, and no one showed up and stuff. And so I had called into the courts, and they said the 255th courts, and they said that to the clerk, and he said, "Oh, the judge here reset that to the 27th. So you're not gonna go today, but you're gonna go in on the 27th. So make sure you're there." And I made sure I was here. I was here at 9:30 waiting and stuff, and then I went on and I just been waiting to be called.
Let me ask you this. What's the Zoom code that you have?
Okay.
Mine, the conference that you would have had would have been in front of Judge Lee.
This is the Zoom code that you talking about for today or the one that was on Tuesday?
The one that would have been on the 21st. Yes, sir.
Yeah, the 21st, it was 915-9144-2553, and that's the one I attended on the 21st.
Okay, so I don't the Zoom code is correct. I don't have any notes in here that says that you showed up. So what I'm going to do is I'm going to,
Let's see if goodness.
have you been talking to, um, Brittany, have you been talking to the coordinator via email?
I talked to her via email, and she had sent me this. This what I'm reading it out of her email that she sent me, and then she sent me I had called in on the 21st. Again, I waited an hour. I was on a call actually there at 9:15 waiting for the Zoom call. I had waited an hour after the meeting because I said maybe they'll call me sometime in it. No one ever called me. And so I called into the clerk office and they said, no, your meeting has been it's been they changed it to they said I guess you the judge, I don't know, but it said it was changed to the 27th, and I said no, I'm supposed to have initial contempt enforcement status conference, and then I have my contemporary enforcement hearing this on Monday, and they said no, the judge pushed everything to Monday the 27th. I said okay, I guess I'll attend on the 27th at 11 o'clock. I said to him, he said yes, 11 o'clock. I said I'll get on the call early today so I can make sure, because I make sure I'm on early. So if you call me as the first case, I'm on the call. But you know, you just saying something to me now and stuff, and then they saying they changing it again. But I was a judge. I was on that call Tuesday on 10/21. I was on a call definitely. I got snapshots to validate it.
Hold on 1 second. One second. Did you receive an email to exchange exhibits?
No, she told me. Brittany here said, because I was asking, "Are you sure?" And she got a. This is the thing she said. Do not reach back out to me as there is nothing else for me to do. It's in big bold letters underlined for me to do at this time. Be sure to serve all parties, which I did serve all parties the papers, and I've done everything.
Let me ask my question again. Did you send any exhibits? It's just yes or no.
Oh yeah, I had attached them and I attached them already. The exhibits is already attached.
Okay, so this is what we're going to do. Send an email to Brittany right now, and then we're going to reopen it and get you a new status conference date. And that way we can move for you to get another date with me today. So from what I'm seeing in the system, that the case was dismissed because you never submitted any actual exhibits. So
There's 4 pages of exhibits. They gave me the when I was there, they said you might want to copy some
Hold on 1 second. I understand your frustration, okay? I can't do anything about something that I didn't have any notice of what was going on. It just came to my attention this morning. So go ahead and send an email to Miss King.
She told me don't email her no more.
She told you don't email her anymore, referencing that because there was nothing else she could do after that point, because Judge Lee is who would need an email from her that shows your exhibits. So let's go ahead and do that right now, okay?
But can I ask you a question?
Go ahead and send it.
No, I'm gonna send it, but when I filed the motion, I attached the exhibits to there. So she should have the exhibits because I attached them.
I'm glad that you said that. Any exhibits that are attached to a motion, I cannot consider because those are not admitted into evidence. So I cannot consider anything that's attached to a motion as an exhibit outside of a special motion, like what's called a motion for summary judgment. Then the exhibits are required to be attached, but the motion that you filed doesn't allow me to consider any exhibits that you attach. So you would have had to detach those exhibits, or you could have left them attached to the motion, but you would have had to send them in a separate email. Does that make sense?
The whole course setting is it's off base and stuff, and I'm considered one that got a high education, and it's so many loopholes in the course system, and so many it's tough, you know, for a parent that really love their kids and give a really good effort. I love my kids unconditionally, and I've done so much for my children, and to go through all of this, it just, you know, and they'll tell me, black men will tell me, you know, you should just walk away from your kids. She giving you all that stress. You don't took very, and I didn't understand it at first, Judge, but now I do understand it. I understand why some men walk away, but I love my kids too much to walk away. But it's so hard. It's so hard. It feel like you're in hell actually, and I'm a Christian that love my children like God required me and take care of them. But it just seemed like you're in hell when you going through all of this stuff. It don't seem fair. And it's not fair. It don't not that it seem it's not fair.
I understand your frustration, especially when you're representing yourself, trying to navigate the court system. That makes it a lot more difficult, okay? So
And, and-
and only
I
thing,
wish I had money to have an attorney, ma'am.
Wilburn, hold on. I have to
Okay.
get to this next hearing. So what I
Okay.
need you to do is to go ahead, log off, send the
Uh-huh.
email to Ms. King. She's going to reinstate your case so we can push it forward. So there's no more delay, okay?
Okay, she kept going back and forth the last time on I got this date and how do you feel about it when
I called her in the courtroom, so she's listening to me.
right, and good. I don't lie to no one. And I had kept picking a date and and she'll say, oh, that one is filled. I just want the next available date without going all back and forth. It's too much for me. The next available date that you have available to get me in the courtroom, and I did, like I said, I attended to both of those settings at the proper time before the hearings on the 21st and today. And now I'm hearing it don't been reset and stuff, and I just would like to go on and get it over with as possible.
That's what we're trying to do. I'm trying to help you. Brittany is right here sitting with me, so she's hearing. I'm looking at her in her face.
Oh, good.
Big instructions, Mr. Wilburn, so she knows exactly what to do. She is waiting on your email.
All right, so send it. I don't have to send it. Just the exhibits you want, right?
Just go ahead and send the email, letting her know that you are requesting an exhibit conference, okay? She'll know exactly what you're talking about because, like I said, she's sitting right here. I'm looking at her in her face.
All right, then. All right.
Okay.
All right. Thank you very much. You guys have a happy Thanksgiving, okay?
Yes, sir. You do the same.
All right. Thank you.
You're welcome. Bye-bye.
All right. Bye-bye.
Okay, Attorney Pinkerton, Attorney Sullivan.
Yes, Your Honor.
All right. Yes, you're good. Thank you, Brittany. All right, so are we ready to proceed on this matter, the Richardson?
Yes, Your Honor.
All right, hold on 1 second.
Yes, Judge.
Okay, I'm waiting on my court reporter to come back. Yes, ma'am. Did you need something else? Okay.
They confused me. So I went down and said, and the gentleman, I was like, I made him pay for these copies, and he said, according to Judge Warren, I don't know, because it's, I don't have a,
Mm-hmm.
he went from last time, he's changed.
Well, that I can't tell you.
Right, no, I know.
Okay. Let me go back to the one that you did previously. That'll probably make it easiest. Yes. 2-4. There is if you go downstairs to the basement, you can request a copy of the capias that was filed so you can see how that look. I think that may be easiest for you. Because the attorney drafted this one. No, it was on, let me see. Yeah, the attorney actually drafted that one. Yeah. Yeah, I will. I'm just trying to get the one that closely resembles this. I think it's probably this one is the best. because this one has, well, no, this one. We'll do this one. We'll do this one. So let me take up this hearing, have a seat, and I'll fill this out for you. Yeah. You're welcome. All right. Let me do this. Since nobody is in the courtroom, I can switch my camera. All right, Joy, you ready? All right, we're on the record in cause number DF 2410679. Counsel, would you please announce for the record?
Kimberly Pinkerton, attorney for Chevalier Richardson.
Thank you.
Daniel Lawrence Sullivan for Troy Wayne Richardson.
Thank you. Would those who intend to testify, please raise your right hands. All right. Do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
Thank you. And Ms. Richardson, if you'll take yourself off of mute.
I do.
Thank you. We are here today on a motion for enforcement for the a property issue. Is that correct?
Yes, Your Honor.
All right. And Attorney Pinkerton, this motion was brought by your client. Is that correct?
Correct.
Okay. You all have 15 minutes per side. That will include any open and closing statements, should you all choose to make them, as well as any examination. Let me tender your exhibits or admit your exhibits at this time.
Judge, I believe there's only one exhibit, which is a summary of testimony by Ms. Pinkerton's client.
Yes, the summary of living expenses.
Yes, Your Honor.
Okay, so petitioner's exhibit 1 is admitted. Attorney Pinkerton, at this time, would you like to make an opening statement?
Yes, Your Honor.
All right, you may proceed.
Your Honor, we're here today on an enforcement hearing for the marital residence. Previously, we were here before Judge Lee on April 15th of 2025, where Mr. Richardson was to vacate the residence by May 16th at 6:00 p.m. Mr. Richardson has failed to vacate the residence. We were brought back before Judge Lee for additional temporary orders by Mr. Richardson for spousal support. And the judge again ordered him to vacate within 3 days after he was provided a $2,500 one-time spousal support payment. And Mr. Richardson has failed to vacate the residence as of today's date. We are here to have the court enforce the order and asking for Ms. Richardson's living expenses to be reimbursed and attorney's fees.
Thank you, counsel. Attorney Sullivan, would you like to make an opening statement at this time?
I'll reserve at this time, Your Honor.
Thank you. Attorney Pinkerton, you may call your first witness.
I call Troy Richardson.
Okay.
Mr. Richardson, would you state your name for the court, please?
Troy Wayne Richardson.
And Mr. Richardson, you are aware of the fact that you were to vacate the marital residence by May 16th, 2025. Is that correct?
Well, actually, she showed
Objection,
up with
Your
the
Honor.
What's your legal counsel?
Oh. Sorry, it was just a yes or a no question he was explaining.
Okay.
So I'm gonna object to the question that it assumes facts, not an evidence, namely that he was supposed to vacate by May 16th. There's no proof of that, and in fact, the opposing counsel's opening statement explains that that's not quite correct, that may originally have been the case, but that order was later modified by Judge Lee.
Okay, sustain.
Your Honor, I would ask that you take into consideration judicial notice of the Associate Judge's reports, both reports from April 15th and July 30th.
The court takes judicial notice of both motions and all contents of the court's file.
Mr. Richardson, are you aware of the fact that you were supposed to have vacated the marital residence?
No, ma'am. Because, you know, because she came with the police there. And I had no way of knowing, because I went to the, I'm sorry, my memory is bad because I have TBI.
Okay.
But I
Your
came.
Honor, I will just pass this witness
Okay.
and I'll call Ms. Richardson.
Well, I think I get to.
Oh, sorry. He
Attorney,
gets to,
do
yeah.
you have any questions?
I do, Your Honor.
Go ahead.
Mr. Richardson, have you vacated the residence as of now?
Yes, sir.
Okay, when did you vacate the residence?
I've been moved in and it's been kind of in and out, but I had to go back to, you know, just like I had a friend that went on a cruise and I've been spending time there, but he just went on that Tom Joyner cruise and he just made it back yesterday or sometime last night or something like that. But I moved my stuff out and I've been doing all that stuff and I've been keeping, you know, I'll go and try to keep the house clean and keep the yard up or whatever. I was doing that so no one would break in or whatever. But because, you know, nobody was there.
Okay. And what is your income situation?
I get the disability check. It's like $644 a month, and I use that for storages. I have 3 storages.
Okay. And how much do you pay on your storages?
It's like $200 and some a piece, and they're going up. They keep going up or whatever, you know.
You're currently paying every penny that you have in income on storage.
Yes,
pretty
sir.
much.
Yes, sir.
Okay. What's a TBI?
Traumatic brain injury.
How did you happen to come by a traumatic brain injury?
I got hit by a car on a motorcycle from behind on Interstate 35, and they was going probably over 100 miles per hour when they hit me.
When
and
was
then
that?
they robbed me.
When was that?
That was July the 8th of 2023.
Okay. Is it your intention to stay in this house?
No, sir. I want to be gone. I really do. I am gone, but I wanted to leave sooner because I've been going through so much behind it.
Pass the witness.
Okay. Anything further from this witness, Attorney Pinkerton?
Yes. Mr. Richardson, when did you move out?
Well, I first moved out. I don't remember any dates, ma'am. But you know, I would have to get things out, and I'm disabled, so and I didn't really have help. So I was moving things out, and then I was supposed to get like some money to get movers, but it never did happen. I never did
Okay,
get the money to
approximately
move
how
out.
long have you been out of the house?
Well, it's been I don't know, to be honest. It's been off. It was, you know, I would leave and then I'd come back and I would, you know, I had still a few things there like clothes and stuff like that. And I would take a shower, change clothes and stuff like that, and then do things around the house and keep the house clean and the yard and you know, stuff like that and inside. And try to keep the house where nobody would break in because I knew I would be it would look like I did it. And I was just trying to protect myself.
When was the last time that you went to the house to pick up any of your items?
Yesterday.
So you still have not completely vacated the residence as of yesterday, correct?
Yes, I have.
And did you notify your attorney that you had moved out?
Well, actually, we hadn't
I'm
talked.
going to object to that calls for, that question invades attorney-client privilege.
And did you notify your attorney that you had moved out?
Yes, ma'am.
Overrule. He answered yes. Counsel, you can ask your next question.
Did you notify Ms. Richardson that you had moved out?
I haven't talked to her, ma'am.
Pass the witness.
Hold on 1 second. You can approach. Yes, ma'am. Yes, you have to take that back down to the clerk's office. Yeah. So yes, that's different from the library. That's where you got it from. So now you have to get it filed and issued. Yeah. Yes, go down to the it's not the basement, it's the first floor.
Thank you.
You're welcome. Have a good day.
Now we know.
All right, so pass the witness. Anything further for this witness?
No, Your Honor.
No, Your Honor.
Okay. Attorney Pinkerton, you may call your next witness.
I call Chevalier Richardson.
Right?
Ms. Richardson, can you state your name for the court?
Chevalier Richardson.
And Ms. Richardson, we provide the court with a summary of your living expenses since June of 2025. Is that correct?
Yes.
And would you agree that your individual living expenses since June of 2025 were $7,250?
Yes.
And you were anticipating on moving back into your house in May, is that correct?
That is correct.
And since May, you have had to not only pay the expenses at the marital residence, but your own living expenses, correct?
Yes.
And are you asking the court to order Mr. Richardson to pay for your living expenses since May
Yes.
and basically reimburse you for your living expenses?
Yes.
And are you also asking the court to award you attorney's fees for having to bring this motion?
Yes.
And have you been to the residence at all?
No, I have not.
Okay, so you
I wasn't aware that he had even left.
okay, so you have stayed away from the residence since all of this has gone on because you weren't aware of him moving out. Is that correct?
That's correct.
Okay. And
Plus the fact that I've given him money to move out that was sent to his attorney.
correct. And the money that you sent previously was $2,500. Is that correct?
That's this past time, but there was $2,000 before that also for moving expenses.
Okay, and in that previous order, it was ordered on July 30th of 2025 for you to pay him $2,500 for moving expenses. Is that correct?
Yes, it is.
And do you recall when you paid that $2,500?
It was within a few days after getting that notice. I took it to his attorney's office.
Okay, and the attorney that you took it to at that time was his previous attorney, Darren Schrader. Is that correct?
That's correct.
And so you are asking the court today to enforce the previous order for him to vacate. Is that correct?
Yes,
And
absolutely.
you're asking the court for him to reimburse you your living expenses in the amount of $7,250. Is that correct?
Yes.
And you are also asking the court to award you attorney's fees in the amount of $4,500 for having to bring this motion. Is that correct?
Yes.
Pass the witness.
Okay. Attorney Sullivan?
No questions.
All right. Attorney Pinkerton, anything further from this witness?
No, Your Honor.
All right, you may call your next witness.
I have no further witnesses.
Okay. Do you rest?
Yes, Your Honor.
All right. Attorney Sullivan?
We also rest, Your Honor, and close.
Okay, I just have a couple of questions. The order from June 2nd, 2025, it ordered that the respondent vacate the marital residence by 6 p.m. on May 16, 2025. Did that happen?
No, Judge, but that said, by that time,
That's all I needed. The other order was the spousal maintenance payment tendered on $2,500 for the moving expenses by what date is this? It doesn't have a date. It's the order is just dated July 30th, 2025. It says wife to provide husband with a one-time spousal support payment of $2,500 for moving expenses. So Ms. Richardson provide to Mr. Richardson?
Yes, Your Honor.
Her testimony was she provided it to his previous attorney, Mr. Schrader.
Okay. All right, so I mean, it's clear from the language of the order in your client's testimony that he didn't vacate the residence by the date.
By which date, Judge? Because Judge Lee provided two different dates. The first was by May 16th, and the second one they went back, and he said that he did not have the money to do it. Then she ordered that he vacate within 3 days of the receipt of the $2,500. So he sought a modification and obtained a modification of the prior order, and there is not evidence before the court that he did not comply with the modified order.
So that date, and there 31 days in July.
Yes.
Yes, Your Honor.
So August 3rd would have been 3 days from July 30th. Was he still living in the house on August 3rd?
There is no testimony one way or the other on that. He is.
Yes, he was.
Was he still living there August the 3rd of 2025?
I don't honestly know that, Judge, and I don't think that the wife does either.
Okay, your client is right there. Sir, were you still living in the house August 3rd, 2025?
No, sir, I had moved my things, but it took me a while, but I didn't get the check, neither one of those checks, the $2,000 or the $2,500. I didn't get neither one of those. I didn't get a penny out of that first $2,000, not a penny.
Okay, Attorney Pinkerton, how do you know that Mr. Richardson was still occupying the residence on August 3rd?
Well, because his testimony, he just stated he was going back and forth. He just went there yesterday to pick up more things.
Right.
And he didn't have any money to move.
So his testimony was he went back to get some things, not that he was still staying there.
Right.
That does make a difference. Him not vacating means that he's not living there, but if he's still picking up things, especially depending on the amount of stuff that he accumulated during the marriage, that doesn't necessarily mean that he was still living there. Is there anything further?
Not for me, Your Honor.
Yeah.
No.
Attorney Pinkerton?
No, Your Honor.
Okay. Based on the evidence presented to the court cannot find that he's in violation of the court order.
Thank you, Judge.
You're welcome. Thank you all.
So when will I be able to move in?
You can go back now. According to his testimony, he's not there. But you know what? This order is missing.
I don't trust him. He's lied numerous times and.
Okay, so here's the deal.
So Your Honor, I think that, I don't mean to overspeak you, but I think what Ms. Richardson would probably be asking you is if she has the right to go now and she can change the locks.
The last time I went, there was a deadbolt lock on the inside of the door, so I would have had to knock the door down in order to get into the home. And if that is still the case, then that deadbolt lock needs to be removed. And if I have to break the door down, then I think that he should be liable for the cost of all of that.
Well, I definitely agree with you there. If Mr. Richardson, is there a deadbolt on this door?
No, ma'am.
On the inside of the front door.
I never changed those.
I didn't say you changed the locks.
Hold on. You all cannot speak at the same time. Mr. Richardson, it's a yes or a no. Is there anything on this door that would prevent her from accessing the home? Yes or no?
She have the keys, ma'am, and I never changed any locks. No.
Judge,
That is not.
The deadbolt means it can't be opened with a key. So whether he changed it or not, if the problem, most houses are gonna have a deadbolt. So if someone's in there, no, most houses don't have a deadbolt.
It is on the inside of the house. So I have the key and the key works, but there's a deadbolt lock on the inside that I cannot enter the home.
Speak at the same time. Attorney Sullivan, you have to let her speak.
Okay, yes, Judge.
Okay, she's saying that even with the key, it's locked from the inside, which means that your client did it from the inside. My question is there anything whether it's on the inside or the outside of the home, that will prevent her from using her key to access the home.
And what I'm saying, Judge, is he can't have it locked from the inside at the moment because he's not on the inside. He's in the waiting room of your
No,
courtroom.
that is absolutely not true. He can always lock the front door and go out the back door, which is dead bolted, and a garage door that I don't have an opener for or a code to. So absolutely, that's how I knew the last time. He was not in the home. The key worked, but I could not enter the residence because of the deadbolt on the inside of the house. And the house was fully locked and I could not enter through any entrance.
Okay, so this is what we're going to do. Ms. Richardson, you are to go to the home to see if you're able to access it. For any reason you're unable to access it and you do have to knock the door down, whatever you have to do to access the home, your attorney knows what to do to bring that in front of me for any payments for damages that as a result of that. Because if Mr. Richardson, if you're the only person that has access to that home and she has not been there, I don't have anything else before me to believe that someone else intentionally locked her out of the home. So, you know, that's how we'll fix that. So any damages as a result of her accessing the home is going to be on Mr. Richardson. Is there anything further?
Yes.
Is there anyone else living in the home?
No, ma'am. No. And can I say something?
I'd much rather you didn't, Mr. Richardson.
Okay, but the Dallas, I mean, the Soto police do know about her coming into the house, taking a lot of my things.
Okay, but we're gonna not deal with that
I
today
did
because it's
not.
not before the court.
Okay.
I do
I've never
think,
accessed the home.
I do think that it might be, if the court wanted to put an order in place that he's not to go inside the home without the permission of Mrs. Richardson from here forward, that might clear some things up.
Well, I cannot do that on a motion for enforcement. So
I mean,
that,
the previous temporary orders gave her exclusive use. They're already in place. So
correct. And I can't, on an enforcement, I can't make additional any substantive changes to the underlying order, which is why I said you have exclusive use, ma'am, okay? So if you're going to the home and you can't access it, whatever you have to do to be able to access the home, any damages to it, your attorney knows what to do in order to bring that back in front of me for me to do something at that time. Does that make sense?
It does make sense, Your Honor, but the enforcement of that, if he's there, then I am not able to access the home. And the judge's order from May 16th, you know, that is why I was there and that is why the police were there and they couldn't enforce him leaving. And I just don't want to have to go through another situation like that where I have to call the police and they can't do anything. And I don't believe that he's even out because he's still going back and forth. And I don't want him at the residence at all after I have moved in.
Let me, because I think I probably didn't make this clear enough. You have exclusive use. So once you're able to access the home, you can do what you want to do to it. So you can make it where you prevent him from being able to access the home. Does that make sense?
Yes.
You don't have to worry about him coming back in. The only way that he's able to come back in is if you don't do anything to keep him out. You have exclusive use of the home. So if you change the locks, you are well within your right to do that. If you want to put a deadbolt, padlock, anything on that door, you have the absolute right to do that because pursuant to this court order, the home is your exclusive use. Does that make sense?
It does make sense, Your Honor. Is there a way to get Mr. Richardson to tell us what he's taken out of the house?
Well, that's beyond the scope of why we're here today. So, you know, when something comes before me related to that, I will address it at that time. But as far as today, is there anything else? You all have any questions before we get off of here?
I do not, Your Honor.
Okay.
We don't either, Judge.
Okay. Well, thank you all. You have a good day. And if I don't see you, happy Thanksgiving to you.
You too,
Same to you,
Judge.
Judge.